Morning, everyone.
Good morning, Your Honor.
Morning.
Your Honor.
Morning, Judge.
Morning.
Good morning.
Good morning. Don't see them. Oh, I see Courtroom Two. Oh, I see. There we go.
Morning.
Good morning.
Y'all ready? We start with number 30.
I'm sorry?
Y'all ready? We start with position number 30, Mr. Surly.
Yeah, there's a little different scenery there.
He's on one of the floor side.
Uh-huh. I don't know if I've seen that one. Hi, Miss Ellen.
Good morning, Your Honor.
How are you?
I'm doing good. How are you doing, Judge?
Good.
This will be a negotiated plea.
Okay. Are you by yourself? No.
No, Mr. Finling is here.
Okay. Let's see. Is he on? Yeah, there he goes.
Morning,
Okay.
Judge.
Hey, good morning. How are you?
Good. Good morning.
All right. Looks like we're about ready. Although I'll probably have to make my announcements twice since there they go. Courtroom Two is not on. Yes, they are on. Good morning, Courtroom Two.
Morning.
Good morning, Judge.
All right, I'll go ahead and make the announcements. Good morning, everyone. I'm Judge Regina Mincy, and this is the state all-purpose calendar for Tuesday, July 19th, 2022 in the State Court of Fulton County. I want to remind everyone that these entire proceedings are being recorded and live streamed on YouTube, so govern yourselves accordingly. You have a right to have an attorney to represent you today, as well as the right to remain silent. And remember that anything that you say about the facts, circumstances, and the occurrences of your case possibly could be used against you later. So be careful and follow the instructions of your attorney. First case we have in 5 South is who?
Number 30, Mr. Surly.
Okay. All right. Starting with position 30, Stephen Surly, case number 22 CR 004408D. You're charged with 1 count of theft by shoplifting. Offense date looks like it's September the 20th, 2019, and I understand this is going to be a negotiated plea. Is that correct, counsel?
Yes, Judge. Correct, Your Honor.
All right. Statement, you may go ahead and proceed.
Your Honor, on this case, we are offering 12 months to serve, 12 months, 60 days to serve, credit for time served, 32 days, balance suspended, and stay away from the incident location, which is 950 West Peachtree Street. That is the Publix in Midtown Atlanta. Nothing further.
All right. Ms. Helen, is that your understanding of the offer?
That is, Judge, and we do stipulate to the factual basis, venue, and ID.
Great. All right, Mr. Sirleaf, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, you can put your hand down. I'm going to ask you a series of questions before I accept your plea and go through the questions that I need to ask you to clarify and make sure that you have an understanding of this plea, okay? All right. And I need to inform you again of your rights, which I've said earlier. And so you are pleading guilty to one count of theft by shoplifting, is that correct?
Yeah.
Okay. Are you under the influence of any medication, drugs, or alcohol at this time? All right. Are you satisfied with the services and representation of your attorney? Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence? That you're giving up or waiving the right to remain silent and not testify against yourself?
Yeah.
And that you're giving up or waiving the right to trial by judge or jury, whichever you prefer? And has anyone told you that you will receive a lesser sentence for pleading guilty?
No.
Has anyone promised you anything to plead guilty?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today? All right, and do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you? I'm sorry? Okay, and so again, as to the charge of theft by shoplifting, how do you plead?
Guilty.
Okay, yeah, we need to hear you. So the court reporter is taking this down. All right, I will accept the plea as negotiated. And again, it is 12 months to serve, 60 days, credit for time served, 32 days, balance suspended, and you are to stay away from 950 West Peachtree Street, the Publix in Midtown. Please don't go back there because you will just be right back in jail again and rearrested. So will you please stay away from the Publix? Okay. All right. Good luck to you. Is there anything else, counsel, that we need to take up?
No, Your Honor.
Anything, Ms. Backus? Nope.
Sorry, I was on mute. Nothing from the state, Your Honor.
Okay. All right. I will sign this. And who's sending me the plea paperwork?
I am, Your Honor. I'll be sending that paperwork to Ms. Champion after court.
Good. All right. That's April Champion for your emails, everybody. Please send them as soon as you can after court. Be wonderful during, but I understand if you can't. All right, who do we have next?
Good morning, y'all. This is Courtroom Two. We got position number 2, Mr. Darrell Blake.
Okay. This is Darrell Blake. Is this a negotiated plea?
That's correct, Judge. This is a negotiated plea.
Okay. This is case number 21 CR 006650J. Darrell Blake, you're charged with one count of theft by shoplifting. State.
Yes, Your Honor, this actually will be a global plea. He has an open case 16 CR 012959J. So this plea will actually resolve both cases. And the terms are as follows: 12 months to serve 10 days, credit for time served 10 days with the balance probated, 2 theft classes, no further contact, and a stay away. And the no contact is with, oops, this is the wrong person, my apologies. Oops. I'm sorry, it's not a no further contact, it's just a stay away from the Dillards located at 7000 North Point Parkway in Alpharetta.
And that is our understanding of the offer, Judge, of which we do agree to the time served. Also, the 2 theft classes. Judge, we would just ask that once Mr. Blake does complete those 2 theft classes, that he could be on non-reporting status. And also, finances are an issue in Mr. Blake's life, so would ask that the probation fees could be waived for a period of time.
And Your Honor, to perfect the record, the no further contact was for the theft by taking case. It's the victim in that case, Miss Alexandria Fishburne, ALEXANDRIA, last name FISHBURN. My apologies to the court.
Okay. All right, Mr. Blake, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Judge.
All right. And I understand that you want to plead guilty today to a theft by taking in 16 CR 012959 and a theft by shoplifting in the 21 case that I read. Is that correct?
Yes, ma'am.
Okay. And I'm going to ask you a series of questions before accepting the plea. And the first one being, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with full understanding of the charges against you?
Yes, ma'am.
And as to the charge of theft by shoplifting, how do you plead?
Guilty.
And as to the charge of theft by taking, how do you plead?
Guilty.
All right, I will accept that guilty plea on both charges. Let me tell you again, the conditions on the global resolution for the first charge of theft by taking is to have no further contact with Alexandria Fishburne. You aware of that?
Yes, ma'am.
Okay, you're to have no further contact with her. And then on the second case, 12 months to serve, 10 days credit for time served, 10 days balance probated, 2 theft classes, and to stay away from Dillard's at 700 North Point Parkway in Alpharetta. Are you aware of that?
Yes, ma'am.
All right, and so counsel, I can allow him to go non-reporting once he's finished with theft classes. But Mr. Blake, you will still be on probation for the 12 months, and I will waive 6 months of the probation fees.
Thank you. I had a question. Excuse me, Your Honor.
Yes,
Initially, when I'm released, where and when do I report for probation?
they will give you that information, or Mr. Finley will be getting in touch with you to tell you that. Mr. Finley, correct me if I'm wrong.
Yes, yes, we will make sure that he gets that information, Judge.
All right, just make sure again, if you haven't heard from anyone, which would not necessarily be the case, but things happen, make sure you get in touch with Mr. Finley as soon as you get out.
Okay, Your Honor.
Okay?
Yes,
All
ma'am.
right, good luck to you.
Thank you.
Uh-huh.
Next, we have position number 18, Mr. Kemp, Theodore Kemp.
All right.
And Judge, this is a non-negotiated plea with just the probation being balance probated or balance suspended at issue.
Okay. All right, this is position 21 CR 0032226C, Theodore Kemp. You're charged with 1 count of theft by receiving stolen property. Is that correct? State, go ahead.
Yes, Your Honor. The negotiated terms are 12 months to serve. The terms are 12, well, the state's offer was 12 months to serve 30 days, Credit for time served 8 days with the balance probated, a theft class, a stay away, and no further contact. The facts are as follows. On September 9th of 2020, officers were dispatched to 78 Meldon Avenue in reference to a stolen vehicle. When they arrived on scene, they spoke with the victim, a Miss Debin Bell, D-E-B-I-N, Bell traditional spelling. She owned a black 1993 Jeep Cherokee, and she stated that she parked her vehicle legally on the street the day before in front of her residence, which is the incident location. And the following morning, she noticed that her vehicle was no longer there. She called the police and was informed that her vehicle had not been impounded. Furthermore, she stated that she was on time with her payment, so a repossession was not a thought in her mind. She also did have possession of her keys. And a lookout was generated for the stolen vehicle, and it was reported stolen at 5:40 a.m. that morning. The officers got her information and left. Further on that day, officers spotted the vehicle that was reported stolen at an Exxon gas station located at 1959 Lakewood Avenue, and the defendant was pumping gas into the vehicle at the time it was spotted. There was also a female passenger in the car. At that time, the officers detained him due to the vehicle being reported stolen, but the defendant was denying the allegations. He stated that an unknown Black male gave him the vehicle in the area of Jonesboro and Sawtell. So the officers were asking him information about the gentleman that gave him the car. He was not able to provide any, not even a nickname or a date of birth. He was able to provide no information as to the person that gave him the car. He also has a history of stealing vehicles, so that alarmed the officers, so they immediately took him into custody. The state feels that this offer is reasonable, definitely due to his criminal history. He has 15 convictions, a lot of them felonies, most of them thefts, ranging from theft by takings all the way to burglaries, Your Honor. We also have some violent offenses in his history as well. Due to those, we ask that you go with the terms set forward.
All right. And I understand, is there, and I guess Mr. Finley will tell me, is there a question at issue balance probated or balance suspended?
That's correct, Judge. So obviously we are agreeing to, oh, wait, sorry, excuse me. So that is at issue. Also, we are asking for this to be a time served plea, Judge. So the time served and for this to be balance probated, balance suspended. Judge, while I do recognize Mr. Kemp's criminal history, that person is very different than the person before you today. He is an older man. He is also a man that you were probably unable to see, Judge, or notice, but he can barely walk. He should be in a wheelchair. He was shot last year in both legs. Not to be too graphic for the court, but he is missing a portion of his left leg and has an open gunshot wound to his right leg. It was pretty hard to look at, but he did show me that, and I can attest he can't walk. He can't walk, he can't read, he can't spell, he has no phone, he has no money, he's homeless. This is a man that has a lot more to worry about in his life than taking a theft class. So I do recognize his history, and I do recognize that he has these thefts, but he's a man at this point that is more concerned with how to get up 2 stairs than anything crime related. These were from 2020. So Mr. Kemp has a extremely hard road ahead of him. And that is why I'm asking for this to be time served and for him not to have this theft class and for not to be on probation. He has no way of getting around. He has no money. He literally can't walk. So that's why I'm asking for the time served, Judge, and the balance suspended.
Your Honor, if I may, I understand the defense's contentions, but this defendant has open robbery from 2021. So even after this offense, He has committed other offense. He also has a possession of forged items that's open with the Marshall County Sheriff's Department. And like I said, he has a total 21 cycles, and 90% of those are thefts, Your Honor, some even being felonies. So the state would object to any modification of the offer.
Yeah. And once again, Judge, I do understand that, but there's one difference between when all of those things happened and right now, and that is that the man before you, I mean, I saw it, he's literally missing a portion of his leg, and his other leg, he has an open gunshot wound. He can't walk. So that's kind of the difference of that man and the man that's before you today. And so that's why, once again, Judge, I adamantly stand where I do.
All right, I'm going to accept the plea, but I will make it balance probated, credit for time served, and I won't order the theft class. So I'll kind of split it up a little bit. So we'll do credit for time served, 8 days. So 12 months to serve, 30 days, credit for time served, 8 days, balance probated. I will waive 6 months of the fees. I will not order the theft class, but he is to stay away again from what location, Ms. King?
It is 78 Meldon Avenue, Meldon Avenue Southeast.
All right, to stay away from there and no further contact with the victim. I assume he will not be stealing anything else if he can't get around. But just to make sure, I don't want to suspend it. I want to make the balance, be probated, be on balance on probation for the full 12 months.
Understood, Judge. I just want to, I do want to correct one thing. So he served 12 days on this, but is there any more jail time for him? Or
No, credit for
Okay.
time served 12 days.
So it would be, I guess, to serve 12 days, and he has served 12 days.
I'm sorry, yeah, I won't say 30 days. I'm sorry, served 12 days and credit for time served 12.
Yes, ma'am.
Okay. All right, Mr. Kemp, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Ma'am, yes, ma'am.
All right, I need to ask you a series of questions. Are you currently under the influence of any medication, drugs, or alcohol at this time?
I was smoking crack.
No,
At this time?
Oh, no, ma'am, no, ma'am, no, ma'am.
Okay, you scared me there. All right. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Ma'am, yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Ma'am, yes, ma'am.
And again, has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea today?
Ma'am, yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Ma'am, yes, ma'am.
All right, I will accept your, excuse me, I will accept your guilty plea to theft by receiving stolen property. The terms are 12 months to serve 12 days, credit for time served 12 days, balance probated. You're to stay away from the address of 78 Meldon Avenue, to have no further contact with the victim, Ms. Bell. And I will waive 6 months of your probation fees.
Ma'am, yes,
Anything
ma'am.
else that I need to take up, counsel?
nothing further. Thank you, Judge.
All right. Excuse me. All right. That will conclude that. Thank you, Mr. Kemp. Okay. Which case?
Morning, Your Honor. Michael Walls representing position number 13, Ms. Maria Gabriela Harriswick. Your Honor, my client has bonded out in the jail, and we'd ask the court to set that procedure. That's the regular judge's calendar.
Okay, she bonded out in the next part. I didn't hear.
Oh, ask the court to send it over to the, I guess, the assigned judge,
Okay.
division judge. I'm sorry.
Gotcha. As far as, so that he's not accepting, you're not accepting the plea, and you are requesting a jury trial?
That's correct, Your Honor.
Okay, and tell me your name again.
Mike Wallace.
Mike Wallace. Okay. And I assume you've entered your appearance, correct?
Yeah, I have, Judge, and
Okay.
I spoke with the case manager as well.
All right, good. So position number 13, 22 CR 0017777F. Madam Court Reporter, that defendant has bonded out. Her attorney appeared in court today, Mr. Mike Wallace, and that case will be transferred to the division judge for a jury trial.
Thank you, Judge.
And you'll be further notice for court.
I appreciate it. Thank
All
you.
right, thank you.
Happy to see you, Your Honor.
Yes, you may be excused. Thank you. All right, who do we have next, Deputy?
Number 28, Mr. Shannon.
Okay.
And that's a negotiated plea, Your Honor.
All right. This is case number 22 CR 004327F. Michael Shannon, you're charged with 1 count of possession and use of drug-related objects, 2nd count of criminal trespass, both with the offense date of July the 5th. And I understand, is this a time served plea?
That is correct, Your Honor.
All right, state, proceed.
Your Honor, that is actually the only condition. Time served, 15 days.
Mm-hmm.
And yes, that's all, Your Honor. That's all from the state.
Okay, gotcha. All right, Mr. Michael Shannon, raise your right hand for me.
Oh, Judge, that is our understanding of the plea. I do stipulate to the factual basis, give you an ID.
Thank you, Ms. Ellen. I almost forgot. Appreciate it. And Mr. Shannon, can you raise your right hand for me? Do you affirm that? And Mr. Shannon, you're in 4 South or Courtroom 2?
4 South.
4 South. I'm sorry. I might have been looking at the wrong camera. Forgive me. All right. Mr. Shannon, do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. And so I understand that we have a negotiated plea. And I'm going to ask you a series of questions, and I just need you to answer them for me. Okay?
Yes, Your Honor.
Are you presently under the influence of any medication, drugs, or alcohol at this time?
Yes, Your Honor.
I'm sorry?
Yes, medication.
Just okay. Are you satisfied with the services and representation of your attorney?
Yes, I am, Your Honor.
And that medication, I'm sorry, is not impairing your ability to understand or make decisions, is it?
Yes.
I'm sorry?
Yes. It makes me pay attention, and I can pay attention more.
But you're able to understand what questions I'm asking you now?
Yes.
Okay. All right. And do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, Your Honor.
Okay. And do you understand that by pleading guilty, you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, I am, Your Honor.
And again, has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes,
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
yes, yes, I am, Your Honor.
Okay, and so as to the charge of possession and use of drug-related objects, how do you plead?
Plead guilty, Your Honor.
And as to the charge of criminal trespass, how do you plead?
Plead guilty, Your Honor.
All right, I will accept your plea. You have no conditions. We are accepting that as a time served plea of 15 days, and you will be free to go once you're cleared by the jail. Okay.
Yes, ma'am.
All right, good luck to you.
Have a great day. Thank you.
Okay, you too. Thank you.
Thank you, Judge.
Mhm.
Yes, we got number 10, Mr. Gaston.
Okay.
And Judge, this is a non-negotiated plea with the no further contact and the stay away at issue.
Okay. This is case number 20 CR 003350J, Blair Gaston.
Yes,
Okay. You're charged with one count of obstruction of a law enforcement officer and the second count of simple battery family violence, both with the offense date of May the 14th, 2020. State, what do we have?
Yes, Your Honor, the terms or the offer given was 12 months to serve 25 days, credit for time served 25 days with the balance probated, family violence intervention program, the stay away and no further contact. On May 14th of 2020, officers were dispatched to 16 Venera Avenue, apartment 8. When he arrived, the 911 caller, who was a young male, named Frederick Best, stated that his mother and her boyfriend were fighting in the home. When the officer came into the apartment, he was immediately met with the defendant and the victim, Miss LaQuisha Patterson. The officers tried to speak to him first, and he yelled explicit words at them and refused to speak to them. At that time, the officer requested more units to come to the home. Then the officer spoke to the victim of the case, and she stated that the defendant kept touching her in ways that she did not want to be touched, grabbing her in different parts of her body. There were no visible marks on her, which is why it is a simple battery. At that point, the officer, after speaking with her and not being able to speak with him, the officers decided to detain him. At that point, he resisted arrest. He began to continue to curse, and got on the ground, and which holding his hands in a position where the officers could not get them. Eventually, they were able to get him into custody safely. The state feels that this offer is reasonable due to the defendant not being reasonable at the scene. Furthermore, the young male and the victim of the case say they do not want to have any further contact with him, and they do not want him in the home any further, and the state agrees with that contention.
Okay.
Yes, Judge, and as previously stated, it is non-negotiated plea with a no further contact and stay away at issue. Mr. Gaston and Miss Patterson have 5 kids together. It's actually pretty cool. They have 3 triplets and then twins as well. So they have 5 kids in total together. Mr. Gaston is going to be employed. He has a job as a cook at Sonic. He's looking forward to getting back to that and getting back to his kids once he gets out. We are, as stated, going against the stay away from the Venera Avenue. That's where she lives and the kids live. He actually will not be living there or living with her. He'll be living with a friend once he gets out. So he won't be living there, but still that's where the kids are, and he will need to be there. Also, Miss Patterson, I spoke with her yesterday, and she adamantly stated that she opposes the stay away and definitely needs and wants contact with Mr. Gaston. She's not afraid of him, and so on. And she wanted to come on the Zoom to speak on his behalf. So it looks like she is here, Judge. It's Miss LaQuisha. And
Oh, I see. Okay.
yes, ma'am.
LaQuisha Patterson. Okay, there you go. Good morning, ma'am. Can't hear you. Now I can hear you.
Can you hear me now?
Yes, I can hear you now. Good morning.
Hello?
Yes, good morning. Can
I'm
you hear
sorry,
me?
I'm having a bit of a system issue with my phone.
Okay, can you hear me?
Yes, I can.
All right.
So yes, as
Hold on a second. You wish to
Mhm.
address the court today? Very briefly.
I'm sorry.
Do you wish to briefly address the court today?
Yes,
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes.
All right, and what would you like to tell me?
I'm sorry. I'm so sorry.
What would you like to tell me today?
Yes. So I was in agreement with Mr. Zach. I don't fear Blair Gaston. It was, and he's the still father of my kids. So I don't want any type of stay away from him because he's been a big help to me and my children.
I just want to make sure that you and your children are safe.
Yes.
Okay, I understand you had a set of triplets and a set of twins.
Yes, ma'am.
I don't know whether to say congratulations or not.
Thank
You have
you.
your hands full, I understand. How old are they?
They are 15 and my twins are 15. My triplets will be 14 next month. So they're a year apart.
Okay, well, I was gonna say if they were babies, but they're not babies, but those teenage years can be just as difficult. So I would say good luck to you.
Thank you.
But anyway, I'm going to accept Mr. Gaston's plea. And hopefully we won't see you all in this forum anymore, okay?
Yes, ma'am.
All right, I appreciate your time for getting on the Zoom this morning. And good luck to you with your children. And so
Okay,
now,
thank you so much.
right, now I'm gonna take the plea from Mr. Gaston. All right, Mr. Gaston,
Yes, I'm here.
okay, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes,
Okay, put your hand down. And Mr. Finley, did you stipulate for me?
Yes, Your Honor. I do stipulate to the factual basis, venue, and ID. And then just one last thing, if he could have the probation fees waived for a period of time, so some of the limited money that he makes could go towards his kids.
Okay. All right, state as far as the plea goes, I will not order the stay away, but I will order no further violent contact with the victim. And with the balance probated, I will waive 6 months of the probation fees. All right. So let me ask you a series of questions. Mr. Gaston, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving, excuse me, the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And you're prepared and agree to waive these rights today, is that correct?
Yes, ma'am. Correct.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes, ma'am.
No. Has anyone told you that you will receive a lesser sentence for pleading guilty?
So, that sentence,
Right, they have not, okay. Has anyone promised you anything to plead guilty?
no, ma'am.
All right, and do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am. I understand.
Okay, so as to the charge of obstruction of a law enforcement officer, how do you plead?
Guilty.
And as to the charge of simple battery family violence, how do you plead?
Guilty.
All right, I will accept that. Your conditions again are 12 months to serve 50 days, credit for time served at 25 days, the balance probated, and I will suspend or waive rather 6 months of the probation fees. You're to take a family violence intervention program. Make sure you complete that. And I know that you have to take the classes in sequence. So don't miss or else you'll have to start all over. But you have 12 months to do that. And I'm not going to order the stay away, but I am going to order that you have no further violent contact with the victim, Ms. LaQuisha Patterson.
Yes, ma'am.
Okay. And wish you good luck. You have 5 children to take care of. So good luck with it to you, okay?
Thank you, ma'am.
All right, you're welcome. All right, that should conclude this case. Anything else from council?
Nothing
Further.
further, Your Honor.
Thank you, Judge.
All right,
Back at Courtroom Two, Your Honor, we got position number 22, Jeffrey Mavelin.
okay. All right, this is case number 22 CR 0004580. Jeffrey, is it Matherly?
Matherly,
Matherly, okay. You're charged with 1 count of theft by receiving stolen property. And that date of the offense was March the 23rd, 2021. State?
Yes, Your Honor. This incident occurred on March 23rd, 2021. An officer was dispatched to an auto larceny call at 1779 Lakewood Avenue Southeast. Upon arrival, the officer spoke with the victim, Mr. Roger Whitley, common spelling, who explained that someone around 6 a.m. had broken into his white Chevrolet van by busting the right side rear window. The items missing included an auto battery charger and a Ryobi impact wrench. The details as to how this defendant was actually discovered are a little bit foggy, how it was identified that it was him. I don't have the rest of the report, Your Honor. As to the defendant's criminal history, he's got 26 cycles in Georgia stemming from 1992 to 2022 and 6 cycles in Florida. His most recent conviction was a 2015 marijuana, but I think the more concerning thing here is that he has several theft violations throughout the years. It looks like he has a theft in 2002, a theft in 2007. He also has several theft arrests, I believe 2010. I believe he had a probation violation for theft. And he's also got several probation violations and failure to appear, Your Honor. And so I think the more concerning thing with this incident is that he's been through the criminal justice system. He knows what the repercussions of his actions are, and yet he still chooses to offend. And Your Honor, this also thefts in this nature, based on the facts that I have presented, you know, these are problematic and can result in violent offenses. And so we're worried about his behavior and how and what can result from that. And so the state's offer was 12 months to serve 20 days, credit for time served 10 days, balance probated, 60 hours of community service, a theft class, and stay away from the incident location, and a no further contact with the victim. And that is all from the state.
All right.
And Your Honor, this is a
Yeah.
bond hearing. I just wanted to make sure this is a bond hearing, correct?
Yes, okay.
Oh, this is a bond here. My apologies, Your Honor. Okay, and so let me pull up 1 second. I need to pull up the case and get the bond. Can you tell me what the current bond amount is, Your Honor?
It's a $2,000 surety, Judge.
Thank you. So I don't have to go through Odyssey. Well, we're asking that the bond not be modified for those same reasons that I made the argument about the offer, just the nature and his history.
All right, thank you. Ms. Helen?
Yes, Judge. Mr. Matherly is 56 years old. We're going to go with the bond factors first, Judge. He's 56 years old. He is a lifetime resident of Fulton County. He is not currently working. However, for the last 35 plus years, he has been a full-time mechanic, also HVAC worker, installation of, honestly, anything from HVAC to cars, Judge. So he is employable and has a skill set to be employable. He is a father of 2 children, 1 boy, 1 daughter, Judge. And so in this particular case, he is pleading not guilty. That's why it's a bond hearing, Judge. We are requesting a signature bond for Mr. Matherly. Currently, there's a $2,000 surety. Based off of the information given from the state, it was kind of pieced together. There are 3 other people mentioned as people of interest in the police report. First person is Jason Smith. Second person is Bernard Jinks. Third person is Angela Spradley. These 3 individuals are mentioned as persons of interest in a police report. I have from Mr. Matherly, he spoke to the detective last year. He is no longer a person of interest in this case. The reason why Mr. Matherly is here is a failure to report. But let's look at the address. The address that's listed is the 1779 Lakewood Ave Southeast. He is not at that address, Judge. He was asked to leave that address with his wife by the police. Why did they ask that? They gave that property to Miss Bradley. This happened last year. Miss Bradley is in possession of 1779 Lakewood Ave Southeast. So Mr. Matherly will not be pleading guilty to a theft by receiving stolen property that he did not participate in at all, and no longer has the property that's listed as the incident that those items were found: a 4-wheeler, let's see, what else? A battery charger. And then from the police report that the state read you, the victim even stated his neighbor, Bernard Jinks, would know who took those things. Those are the 3 people: Bernard Jinks, Jason Smith, and Miss Angela Spradley are the people of interest. Mr. Matherly is here for a failure to appear, but he didn't get that notice because it's at the address that he's been asked to leave, at the 1779 Lakewood Avenue. Judge, I'll be honest with you. There is a separate case of fraud, different things happening at that 1779 Lakewood Ave Southeast. But Mr. Matherly does not have possession of it. He has been dispossessed. He's been put out with his wife. He did not receive the notice from May 25th of this year to be there because he's not at that address. So Judge, we are asking for a signature bond. Mr. Matherly did not commit any other crimes. This case is still open. He is not pleading guilty to it because he did not do it. And he was not in cahoots with those other 3 people who were actually mentioned as people of interest in a separate case, Judge. So we are asking for that signature bond. And if not that signature bond, we are asking for a bond modification to $1,000 surety, Judge.
Your Honor, there was a signature bond in place, but also even if he's not at that address, it is still his responsibility to update the court with his address. And so that's really no excuse for a failure to appear. And as she said, the case is still being investigated. The case is still open. And so therefore he is not cleared of anything. And so Your Honor, we are asking for the $2,000 bond to stay in place.
And what's the date of arrest?
The
Ms.
date of
Helen?
arrest was 3/23/2021. Or I'm sorry, that was the date of the incident. Let me
I was
look
gonna
at the
say
date
no,
of arrest.
yeah.
Yeah, that's the date of incident. Hold on one second, Your Honor.
Mr. Matherly was booked on June 29th, 2022. He spent 22 days there, Judge.
That is correct.
Okay. Beside this case, did I hear anything, Ms. Backus? Does he have any other open cases?
I do not believe so. As I stated, well, actually, that's not true. He has a 2020 driving while suspended, a 2022 marijuana, but the last conviction was in 2015. He does not have any, I don't believe he has anything open other than those 2.
Okay.
And Judge, I do want to make a note, when his history was read, the last theft conviction was over 15 years ago.
What's the 2015 conviction that's not theft?
It's marijuana.
Okay. All right, I'm going to give a $4,000 signature bond. And I'm going to give that signature bond through pretrial. And again, stay away from the 1779 Lakewood Avenue Southeast. And no further contact with the victim. Is it Roger Whitley?
Yes, Your Honor.
All right, those are your conditions, and no drugs, alcohol, or weapons while on bond. All right, Mr. Matterly.
Yes, Your Honor.
All right, good luck to you.
Thank you, Judge.
Hold on,
Your Honor.
second, yes. Oh, I need to arraign you, Mr. Matterly. As well, before you go.
Okay.
All right, and again, I want to inform you that you have a right to remain silent. Anything that you say about the facts and circumstances of your case can and will be used against you. And again, attorney, Ms. Helen, do you waive a formal reading of the accusation, or do you want it read?
I waive, Your Honor.
Okay, so we waive the formal reading. And again, Mr. Mattingly has been charged with a one count rather, of theft by receiving stolen property. You've been formally accused by the Solicitor General's office, and this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case will be reset for a jury trial. The trial will be scheduled by the state court judge to whom your case is assigned, or the division judge, as part of the notice for trial. Make sure that you keep your address updated with your phone number with the clerk's office, which I'm sure your attorney will do the same. And again, at the jury trial, you also have your right to an attorney, which you have Ms. Helen at this point. And you do not have the burden to prove your charges at trial, but the state does. They're represented by the Solicitor General, and they will bear the burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, again, you could face a sentence of up to 1 year in prison or a fine of $1,000 for the charge. And based upon this information, how do you plead to the charge of theft by receiving stolen property?
Your Honor, I plead not guilty.
Not guilty. All right. You have been arraigned and I will accept your not guilty plea. The case is arraigned and further noticed for trial by the division judge. All right.
Thank you,
Your Honor.
Judge.
All right. You're welcome.
Thank you, Mr. Matherly.
Thank you.
Thank you, Your Honor.
Next, we have add-on 1, Mr. Christopher Day. Add-on
Alright.
1.
Add on 1. This is 22 CR 002756G. Christopher Day. You charged with 1 count of SB. Do we need to go into a breakout? Or can we?
Yes, I think that'd be good, Judge.
Okay. Is it Mr. Jordan? He's okay. Mr. Jordan, can we go into a breakout with the add-on number 1?
Who all needs to be in the breakout room, Judge?
Ms. Backus, Mr. Finley,
Mr. Walker as well.
Mr. Walker. All right, are we back with Mr. Day in courtroom 2?
Yeah, we're still ready. We'll wait.
All right, this is 22 CR 002756G. Christopher Day, are you ready to take a guilty plea to the SB charge that we have before us?
Yes, ma'am.
Okay, I'm going to ask you a series of questions. First, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. And again, I need to inform you that you do have the right to remain silent. Anything that you state at this time can and will be held against you. Are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
I am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Do you understand that you're giving up and waiving the right to see, hear, and confront your accuser and all witnesses called to testify against you?
Yes, ma'am.
Do you understand that you are prepared to agree and waive these rights today?
I am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, that your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily
I do.
with the full understanding of the charge against you?
Yes, ma'am.
And as to the charge of SB, how do you plead?
I plead guilty.
All right, I will accept the plea as negotiated. The terms are 12 months probation to serve 180 days. I'm giving you credit for time served at 77 days so that you will not have to serve the additional 13 days. The balance will be probated. You are to do the SDET. No further contact with the victim, Tamia Amarat. You are to stay away from the incident location, which is the 5 Points MARTA, and to comply with that MARTA suspension, which is 365 days. So you are to take other means of transportation unless you're not going to the 5 Point station. I don't know, again, counsel, if he's banned from all of MARTA or just from the 5 Points, which is the hub of MARTA. Do we have any clarification on that?
I believe, I think it said, if I'm not mistaken, just to, maybe it was that specific station and then to abide by any kind of suspension if there is one.
Okay.
And also, Judge, just one quick thing. I know you said 180 days. I just want to make sure that it's the 154 days.
I'm sorry.
Which would mean the time served.
Right, I'm sorry. Yes, 154 days. And not 180. I apologize.
Yes, ma'am. And then also, Judge, if you could just have the probation fees waived for a period of time.
I'll waive 6 months of probation fees. But Mr. Day, when you get out, I think they have provisions where you can check with MARTA to make sure about your suspension date and what it states. I've heard it in other cases where they're able to contact MARTA to find out about the suspension so that you don't revoke on your probation by going there or thinking that you can go to other stations or ride the bus. You need to clarify with MARTA what their suspension is, whether it's all MARTA or just that you cannot go to the 5 Points, so that you will be clear on the terms of your probation.
Yes, ma'am.
Okay, all right. That will conclude this case. Thank you very much.
Thank you, Your Honor.
Thank you, Judge.
Your Honor.
My apologies, what position?
Next, we go on to position number 3, Mr. Donald Burks, position number 3.
And this is a negotiated plea, Judge.
Okay. This is case number 22 CR 004388C. Donald Burks, you're charged with 1 count of theft by taking, 2nd charge of criminal trespass and damage to property, and a 3rd charge of possession and use of drug-related objects, all with the offense date of December 15, 2021. And I understand this is a plea state. You may proceed.
Yes, Your Honor. The negotiated terms are 12 months to serve 365 days, credit for time served 211 days.
All right. Mr. Finley, is that your understanding?
Yes, Your Honor. That is our understanding of the offer, of which we do agree to the time served. We would just ask, or sorry, there's no probation. So, and we do stipulate the factual basis, venue, and ID.
Okay. All right, Mr. Burks, can you hear me? Okay, I think you're muted in courtroom 2. Ask the deputy to unmute you. Okay. All right, Mr. Burks, can you hear me?
Ma'am.
All right. Again, Mr. Burks, I'm going to go over some questions with you in order to accept your guilty plea. Are you raise your right hand for me. Do you affirm the testimony you're about to give us the truth and nothing but the truth under the penalty of perjury?
Ma'am.
All right, put your hand down. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you are giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And that, has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
So as to the charge of theft by taking, how do you plead? And then as to the charge of criminal trespass and damage to property, how do you plead?
Plead guilty.
And as to the charge of possession and use of drug-related objects, how do you plead?
Guilty.
All right, I will accept your guilty plea on those 3 charges. The plea is, the terms and conditions of this plea are 12 months to serve 365 days, but credit for time served at 211 days. All right, I'll accept that plea. Good luck to you.
Thank you, ma'am. Thank you. Thank you.
All right.
Next, we have position number 21, Mr. Lockett, Jimmy Lockett.
Okay. This is 22 CR 004321C. Jimmy Lockett, you're charged with 1 count of criminal trespass with the, I don't see my offense date. But this is this to be a plea? Ms. King and Ms. Helen?
It is, Your Honor. It's a negotiated plea.
All right. Go ahead, Ms. King.
Yes, the negotiated terms are 12 months to serve 30 days, credit for time served 15 days, with the ballot suspended and a stay away from the incident location.
Okay. What's the incident location?
This is Ms. Bacchus's case. She is having technical difficulties. It will just take me a second to find out.
Okay.
Your Honor.
I just made it back.
Oh,
Hi, everyone. So what position
okay.
are we on?
We're
need
at
the
position 21.
Do you have the
I
incident
think
location?
she's back. I think she froze on us again.
Okay, let me see if I can find it.
Can you hear me now?
Uh,
Can you hear me
yes,
now, Your Honor?
we can, but it's kind of in and out and dragging. I'm not sure if you have a great connection. It seems a little. You're
The
freezing.
incident
on me.
location is the Ameris Bank located at 494 Ponce de Leon Avenue in Atlanta.
Okay.
My apologies for the delay.
No, it's okay. It's raining out there. Ms. Bacchus, you're in and out with me. So I'm letting Ms. King kind of take
Yeah,
over.
there's some lines down in my area, Your Honor.
I bet. It must-
So I'm trying. Can you hear me now?
We can. I think I'm going to go with Ms. King for a moment because your picture isn't very clear,
Okay.
either, which tells me your connection's not great.
Okay.
Okay, we'll let her do it
Okay.
for you. All right, go ahead, Ms.
Thanks.
King. I think you've said everything, or is there anything else to add?
Yeah, it's just to stay away from Ameris Bank, 494 Ponce de Leon Avenue in Atlanta.
Okay.
And yes, Your Honor, that is our understanding of the plea. We do stipulate to the factual basis, venue, and ID.
All right. So, Mr. Lockett, can you hear me?
Yes, ma'am.
Raise your right hand for me.
Yes, ma'am.
Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, you can put your right hand down for me. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services of your attorney?
Oh, I'm great. Yes, ma'am.
Okay. Do you understand that by pleading guilty today, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am, I do.
And do you again offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am, I do.
Okay, I will accept your plea as it has been read and presented. And again, how do you plead to the charge of criminal trespass?
I'm guilty.
All right, so that's 12 months to serve 30 days. I'm sorry, 12 months probation to serve 30 days, credit for time served at 15 days, balance suspended, and to stay away from the Ameris Bank at 424 Ponce de Leon Avenue. Can you do that?
Yes, ma'am.
Okay, make sure you do it, else you'll be back in the Fulton County Jail.
Unfortunately, yes, ma'am.
All right, good luck to you.
Thank you.
Mhm.
Next, we have position number 23, Mr. Maxim.
Negotiated plea, Your Honor.
Okay. This is case number 22 CR 004142E. Mavelin Maxim, you're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count of disorderly conduct. Actually, it's 2 counts of disorderly conduct with the offense date of June 28, 2022. State?
Yes, Your Honor, the negotiated terms are 12 months to serve, 42 days, credit for time served, 21 days with the balance probated, and a stay away from 900-13 Mansell Road in Roswell.
Judge, we
Your Honor,
have,
it should be balance suspended.
thank you, Judge. That is the
I
good.
thought it said balance suspended.
Oh, no,
That's
no, it's
what-
okay. I just wanted to clarify and make sure it's balance suspended and then stay away from that incident location.
which is 900-13 Mansell Road.
That is correct.
Okay. All right, that's your understanding, Ms. Helen?
Yes, Judge, that is understanding that it's a time served, balance suspended plea. We do stipulate to the factual basis, video and ID.
All right. Mr. Maxim, can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, and put your hand down. Are you presently under the influence of any medication, drugs, or alcohol at this time?
Your Honor, good morning. I just wanted to say after 3 weeks, it's an absolute.
Mr. Maxim, if there's something you would like to speak to me about your case or anything else going on at the jail, we can do that. But the judge is only asking you if you want to plead and accept this plea of guilt in the case that I talked to you about, okay?
Pleading not guilty. Due to some new developments, I'm pleading not guilty, Your Honor.
Okay, so you do not want to accept the plea that the state has offered?
Absolutely not. At this time.
Okay.
And so, Judge, we can do a bond hearing.
Okay, but we will do a bond hearing. All right, state, go forward. And I think Ms. Backus is back with us. I can see you clearly now. You want to try it?
Yes, sure. Give me 1 second. I'm sorry, I'm having to pull my system back up, so.
Right, no problem.
Oh, no, Odyssey is acting up. Your Honor, I can give you, I can't get into Odyssey right now because of my connection issues. I'm sorry.
Okay. Ms. King?
Can you?
Yes.
Okay.
So you want the bond conditions? Okay. Let me see.
Or his criminal history?
He has $3,000 surety bond and maximum. His criminal history, he has 6 cycles. He has history out of Texas as well, from 2011, a driving while intoxicated, driving while license suspended, and assault of family and unlawful restraint. That case is still open from 2021. He also has a criminal trespass from 2021, a disorderly from 2020, a reckless driving from 2010, and a DUI from 2008. So we asked that the $3,000 surety remain in place due to his close criminal history. All of these arrests are from 2011 to 2022, so that's almost one for every year. We feel that the $3,000 surety is a reasonable bond for this defendant.
All right, Ms. Helen?
Hey, Judge, can I get pretrial services to read his history for me?
Yes, pretrial. Good morning. Good morning.
I'm showing 10 cycles with history in Texas, Georgia, Florida, and Nevada. Last arrest was May of 2021 for assault caused by bodily injury of family member in El Paso, Texas. No disposition listed on that arrest. One moment. His GCIC is not showing any convictions outside of Georgia.
Okay.
With the exception of a 2014 driving while intoxicated out of Texas. Nothing further to add.
And so, Judge, hearing his history, I didn't hear a violent dangerous, long-standing history. Mr. Maxim is not a violent, dangerous individual. I do hear the allegations of this case, which is with some employees of a top dog establishment in the establishment next door, but there was no contact or physical violence mentioned or alleged from Mr. Maxim. He had rollerblades in the store and was asked to leave, and he did, Your Honor. And so with his history, again, not being violent, we are asking for a signature bond for Mr. Maxim. Again, he cannot afford the $3,000 surety. So we are asking for it to be a $3,000 signature because, again, Mr. Maxim cannot afford the $3,000 surety bond himself out. And with the Ayala factors, he will come to court. I have expressed to him how serious these cases and these counts are. He understands he needs to come to court. I have contact information from Mr. Maxim. And so, yes, Judge, we are asking for a signature bond in the amount of $3,000 for Mr. Maxim.
Your Honor, if I may, the victims of who are the employees of the store did state that they were fearful when he began to yell at them, and he even removed his shirt. He was being very aggressive towards these young ladies. So while he might not have touched them, they were fearful that he may. Furthermore, Your Honor, with him having an open case in Texas from 2021, we're concerned that he may be a flight risk. He obviously travels very frequently between states, and the state's concerned he will not come back to court. Due to him having a criminal history in so many different states, recently, the state asked that a $3,000 should remain in place.
All right, I'm going to continue with the 3,000 surety bond. And do I need to arraign him?
Yes, Judge.
All right, you waive the formal reading of the accusation?
I do, Your Honor.
All right, Mr. Maxim, I'm going to arraign you and formally let you know of the charges. It is a perfunctory matter that we have to do in the court. Since you're not going to enter the plea, your attorney has waived the formal reading of the accusation, and you have been charged by the Solicitor General's office with 1 count of willful obstruction of a law enforcement officer and 2 counts of disorderly conduct. And those charges have been formally accused by the Solicitor General's office in Fulton County, and each charge carries a maximum sentence of 1 year in jail and a maximum fine of $1,000 for each of those charges. This case will be reset for jury trial, and the trial will be scheduled by the state court judge to whom this case is assigned as further notice for trial. Make sure that you keep your address updated with your attorney as well as the clerk's office to receive those notices. At the jury trial, you will have a right to an attorney. You do not have the burden to prove the charges at trial. The state, represented by the Solicitor General's office, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do not get a conviction, if they do get a conviction, you could face a sentence of up to 1 year in prison or a fine of $1,000 for each of the 3 charges. They could run concurrently or consecutively. Based upon this information, how do you plead to the 3 charges that I have just read?
Your Honor, I plead not guilty. My only discretion is there was nothing out of Georgia conviction.
I'm not having the trial. I'm not conducting the trial. I just asked about your plea. And if your plea is not guilty, I will accept that. You have been formally arraigned and you will be further noticed for trial. All right.
Much obliged. Thank you, everyone.
Thank you,
All right,
Judge.
you're welcome. Thank you.
Next, we're gonna have position 33. He's also add-on 5, Mr. Stevens.
And position 33 is a conflict attorney position, Judge.
Okay.
I believe McLeod is on.
I think I saw Ms. McLeod.
She's in a breakout room, Judge.
Okay, so we can.
She's gonna represent Mr. Jackson also. So she's
Okay.
she's on the phone with Mr. Jackson at the moment.
So we can move to position number 8, Mr. Dew, Elwood Dew.
Okay. You said 8.
Yes, position 8.
Okay. This is 19 CR 002020Y. Mr. Elwood, is it Dugu?
Duque, Your Honor.
Duguay, okay. Sorry about that. Your charge is 1 count of theft by receiving stolen property. Plea,
That's correct, Judge. This is a negotiated plea.
negotiated plea. All right, state.
Yes, Your Honor, the offer is 12 months to serve 4 days, credit for time served, 12 months to serve 8 days, credit for time served 4 days, with the balance probated, a theft class, and a stay away. Trying to get the incident location, 1 second.
Okay.
And Judge, that is our understanding of the offer, of which we do agree. I would just ask that once Mr. Duguay does complete the theft class, that the balance of his probation could be terminated.
The incident location is Maynard Terrace. So a stay away actually would not be, because it appears to happen in the middle of the road on I-20 East when he was seen with the vehicle. So the state removes the stay away from the offer. That would not be necessary.
Okay.
So just the theft class.
Okay. All right, Mr. Finley, is that your understanding of the plea?
Yes, Judge, that is our understanding of the plea. We just ask that once Mr. Duguay does complete that theft class, that his probation could be terminated at that time. And also that the probation fees up until then will be waived.
Any objection from the state on the termination once he completes the theft class?
Due to his lack of criminal history, there's no objection from the state.
Okay. All right, Mr. Duguay, I'm sorry, Mr. Finley, stipulating?
Yes, Your Honor, we stipulate the factual basis venue and ID.
All right, Mr. Duguay, can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, I'm going to ask you a series of questions in order to accept your plea. And I want to ask you at this time, are you currently under the influence of any medication, drugs, or alcohol at this time?
No, Your Honor.
Do you understand that, I'm sorry, are you satisfied with the services of your attorney at this time?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
Do you understand that by pleading guilty, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
And do you understand that you're giving up and waiving the right to trial by a judge or jury, whichever you prefer?
Yes, Your Honor.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
Do you understand that if you're currently on probation, you may be revoked because of your guilty plea here today?
Yes, Your Honor.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, Your Honor.
All right, I will accept your guilty plea. That is 12 months to serve, 8 days, credit for time served at 4 days, balance probated. You're to take a theft class. And once you complete that theft class, your probation will be terminated. And I will waive 3 months of the probation fees. All right. That should conclude this case. Anything else from counsel?
Nothing further. Thank you, Judge.
All right. Good luck to you, Mr. Duguay.
Thank you, Your Honor.
Next, we got number 14, Mr. Jackson.
Okay. All right, this is 22 CR 004128Y. Looks like this is Raquel Jackson. Sorry to mispronounce your name. You're charged with 1 count of obstruction of a law enforcement officer, loitering or prowling, and possession of a pistol or revolver by a person under 18 years of age. All with the offense date of June 27, 2022. And this is to be a plea, is that correct?
Your Honor, I have been talking with the prosecutor in the hopes that it could be a plea, Your Honor, but we haven't really reached a negotiated plea yet.
Okay.
There is an offer.
Okay. So are we just arraigning him with the not guilty or?
Yes, it is a not guilty,
Okay.
Your Honor, at this time. My client has a bond which he's been unable to post. He is only 18 years old. He actually turned 18, Your Honor, since he's been locked up. He's been locked up, I believe, 17 or 18 days now. He is in no position to pay bond. He lives with his mom and his stepfather. They are not able to help him, Your Honor. And it just seems that he's going to be sitting.
He graduated from high school?
Has he graduated from high school? Yes, Your Honor, he has.
Okay. What high school?
Grady High School.
I'm sorry?
Grady High School.
Grady High School? Okay.
Grady High School.
All right, and the bond currently is?
I believe it's $3,000, Your Honor, good bond. But he's not in a position to make bond.
Your Honor, the state requests that the bond remained as set due to his criminal history and the facts of the case.
All right. And would you like? Go ahead.
Yes, the defendant has an open case out of Cobb for theft by taking and obstruction. He received that in December of 2021. That was a mere 6 months before the case that's before Your Honor today. And on June 27, officers were dispatched to 8th Street and Cypress Street due to 2 males looking into multiple vehicles. When he arrived, he was met with a witness who actually saw the defendant and another male he walked into the parking deck past the gate arm and went into the parking garage and started pulling on door handles and was looking in the vehicles. When the officers approached them and told them not to move, they both took off running. The officers were able to get both defendants into custody, and they both had firearms in their waistbands. The defendant actually had a black Taurus with him, a handgun, which was very alarming to the state, as well as the officers on the scene when they were taken into custody. And I understand that, the defendant's age, but while he was 17, he committed 2 theft offenses. And we see where this is going, Your Honor. So for that reason, the state is requesting that the $3,000 surety remain in place.
Your Honor.
Mr. Cloud?
Yes, Your Honor, to say that we see where this is going, my client doesn't have any convictions. He may have been arrested when he was 17, as the state says. So to see where this is going, he has not committed any violent crimes, Your Honor. He's still only an 18-year-old. He had his birthday while he was locked up in jail. He does have somewhere he can go back to his mom and his stepfather. He has told me that. Asking him to spend a whole year in jail, I think, is excessive given what the charge is. So I would ask the court to take that into consideration and give him a signature bond, Your Honor, since we can't come to an agreement as to what would be a reasonable punishment for my client in this situation.
And Your Honor, the bond isn't a punishment in the imposition of the state. We're talking about the IILA factors. He has reoffended, Your Honor, already. And we feel that he will reoffend again if we do not intervene, Your Honor.
Well, he has not reoffended with respect to this particular charge.
Yes, this offense was a reoffense. He was out on bond for another case when he committed this offense.
But they're not the same offense, though. In fairness, they are different things.
And Ms. McLeod.
Yes, Your Honor.
The defendant was 17 at the time, now 18.
He was, Your Honor. Yes, he had his birthday while he was locked up.
Okay. And I'm assuming he was not working. He stated he graduated from high school.
Yes, Your Honor.
And so he was not working or anything?
He was not, Your Honor.
Still living at home?
Yes, Your Honor, with his mom and his stepfather.
And so what about his family life or his parents? They're not able to post bond?
No, Your Honor, they are not in a position to post bond for him. That's why he's been sitting in jail now. It's going on a month. It's about 20 days now, I believe. Somewhere between 17 and 20 days.
I am concerned about the charge, certainly the gun charge, the allegations of that, and the open case in Cobb from last year, it looks like.
Yes, Your Honor.
Late last year, Your Honor.
Mm-hmm. I'm going to I guess I need to arraign the case as well, accept his not guilty plea.
Yes, Your Honor.
Arraign the case, and as far as bond, I'm going to leave it at the $3,000 surety bond. All right, Mr. Jackson, I'm going to arraign you at this time. Do you waive the reading of the accusation? Formal reading of the accusation, Ms. McLeod?
Yes, I do, Your Honor.
All right. And so, Mr. Jackson, you have been charged with one count of obstruction of a law enforcement officer, loitering or prowling, and possession of a pistol or revolver by a person under 18 years of age. And each of those charges carries a maximum sentence of 1 year in jail or a maximum fine of $1,000 for each of those charges. Those have been formally accused by the Solicitor General's office in Fulton County. This case will be reset for jury trial, and the trial will be scheduled by the state court judge to whom this case is assigned as further notice for trial. Make sure that if you get out on bond, you keep your address and phone number updated with your attorney, as well as the clerk's office. Just want to let you know that you do not have the burden to prove the charges at trial, but the state, represented by the Solicitor General's office, will bear that burden and will have to convince the jury beyond a reasonable doubt in order to get a conviction in this case. If they do get a conviction, you could again face a sentence of up to 1 year in prison or a fine of $1,000 for each of these charges, and they will either run concurrently or consecutively. Based upon this information, how do you plead to the three charges, Mr. Jackson?
Can you say that one more time for me, please?
Based upon the information that I've just given you about the formal charges from the Solicitor General's office, how do you plead to the three charges against you?
Not guilty.
Not guilty.
Okay. All right. I will accept your plea of not guilty, and this case will be reset for trial with the division judge. All right. Okay. Thank you.
Thank you, Your Honor.
Mm-hmm.
Okay. All right, next in courtroom 3, position 33, add on 5.
Okay.
Okay, this is the number I called is.
Okay, this is Ms. McLeod's case.
Yes, Your Honor.
All right, we have 2 cases with Mr. Renardo Stevens.
Yes, Your Honor.
Okay, the first case is 22 CR 004303J. Mr. Stevens, you're charged with battery family violence with the offense date of April the 9th, 2022. Is that going to be a plea?
Yes, ma'am.
Okay, and then the second case is 22 CR 004527J. Another charge of battery family violence. That offense date is May 24th, 2022. I show on that one, is there an offer?
To my understanding, there was no offer, Your Honor.
Okay, is that correct, State? On the add-on case, there's no offer yet?
That is correct, Your Honor, and I believe that that is because, let me look at the add-on really quickly. I believe that the reason why there was no offer is because by operation of law, if he was to plead to the first case, that makes the second case, right, a felony transfer. And so that's why there's no offer.
All right. Ms. McLeod, are you still wanting to plead to the first case?
Well, I haven't had a chance to talk to my client about it, Your Honor, but it sounds to me like it's probably not a good idea for him to do so at this time.
Okay. I thought, now this was not the case you were already in the breakout with?
No, I was talking with Mr. Jackson, Your Honor.
Oh, I'm sorry. Okay.
That's
I was
okay.
thinking it was this one. I apologize.
No, no, Your
Right.
Honor.
Mr. Jordan, would you like to speak to your client?
I would, Your Honor.
Okay. Can you put Ms. McLeod back in, or does she need to call?
They will probably have to call her from the jail.
I think they
'cause
need
it
to
looks
call
like they
me,
got
Your
everybody
Honor,
else.
but I'm available. I'm waiting for the call.
Okay, Deputy, Ms. McLeod needs to call in to courtroom 2, speak to the defendant.
If I need to call in, I can do that. I just need the number.
And she would just need the number.
404-612. 2392.
Okay, thank you.
Can you say it again, please?
2392 612.
Yes.
2392. Okay, thank you.
Okay, all right, we'll come back to you.
Come on, Heather. Position 12.
Okay. Let's see, Mr. Finley needs to speak to Mr. Hegler.
Yeah, so I did briefly speak with Mr. Hegler, Judge. So this is going to be a negotiated plea.
Okay.
I was just trying to contact probation. I've been unsuccessful. Just trying to, Mr. Hegler wanted me to inquire if he has a hold. And I believe I saw one, but I just wanted to double check with somebody from probation.
Probation or pretrial? I don't know. We can see if pretrial has it. I don't know.
I would have to get a probation officer on the phone.
Okay.
I'm just an intake officer.
Is there a number? Is there a number I could call that I haven't?
678 298 7901. Do you know his probation officer number? I mean name rather?
You know the name, Mr. Hegler?
No, ma'am, Ms. Thomas. Every time I call, they say I'm not on record by name or social security number.
Well, I'll Mr. Hegler, we can go forward with the plea like you wanted to, and I will I'm gonna get in contact with him and I'll figure it out, okay?
Sorry to interject, but if there's a probation hold, I'm pretty sure it will show on the jailing screen, correct?
So yeah, it has like a little R next to it, but I guess Mr. Hegler called and they said they didn't have anything showing up. So that's where it's confused.
I understood.
Yeah. But yes, you're right. I did see that, Mr. Walker.
All right, are we taking the plea?
Yes, ma'am. Yeah, we are moving forward the plea.
All right, this is case number 21 CR 001511F, John Hegler. The charge is 1 count of theft by taking. The offense date is February the 9th, 2020. Ms. King?
Yes, Your Honor. The negotiated terms are 12 months to serve 365 days, credit for time served 197 days.
Okay. All right,
And,
Mr. Finley, is that your understanding?
Yes, Your Honor. That was our understanding of the offer of the time served. And we do stipulate the factual basis, venue, and ID.
All right. Mr. Hegler, raise your right hand for me. Do you swear that the testimony or affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. I'm gonna ask you a couple of questions. And the first one being, are you presently under the influence of any drugs, alcohol, or medication at this time?
No, ma'am.
Are you satisfied with the services of your attorney?
Yes, ma'am.
Are you, do you understand that by pleading guilty, you're giving up or waiving your right to the presumption of innocence?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving your right to remain silent and not testify against yourself?
Yes, ma'am.
And do you understand that you're giving up or waiving your right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, and so to the plea of theft by taking, how do you plead?
Guilty.
All right, and so the plea and the terms are 12 months to serve 365 days, credit for time served 197 days. And that is it for the no other conditions, is that correct?
Yes, ma'am.
All right, and so Mr. Hegler, I will accept that plea and good luck to you. Okay, great. All right, we'll be right with you. Running a little behind. All right, who do we have next?
That with position 33 and add on 5.
33 add-on.
And officer, could you have Mr. Hegler give me a call really quick? Or I'll call. Thank you.
This is Mr. Stevens.
Yes, ma'am.
All right. Waiting on Ms. McLeod. Ms. McLeod? Yeah, correct, right?
Yes, I think we lost.
Did we lose her?
I'm here, Your Honor.
Okay, I thought we lost you. I know, is it still raining outside, by the way? I know when it rains in Fulton County, things happen. All right. So, Ms. McLeod, we have the two cases with Renardo Stevens. And what
Yes, Your Honor.
would be your announcement?
Your Honor, the state has an offer on one of the cases, and I'm hoping that they would consider just extending the offer to cover both cases.
Ms. King or Mr.
I'm
Walker?
going to take the case. As was stated earlier, your second battery family violence by operation of law is a felony. So the state is not in a position to take a plea on a case that's not a misdemeanor. So if you were to take a plea on the first one, unfortunately, the second one is felonious. That's the law. So we're not in a position to extend an offer on add-on 5.
All right. Ms. McLeod, what would you like to do?
Is there a bond for my client on the second one?
Is there what now?
A bond. I'm not sure if there's a bond.
Oh, is there a
Look it
bond
up. I know on
add-on
the
5?
first one is a 3,500. I'm filling in for Ms. Bacchus, as you know, she's having IT
Okay.
issue. So just bear with me, Your Honor.
Okay.
Let me look up the second case.
Hello? All right, all I heard was you got a message from the text message.
I have the second bond order, Mr. Walker.
Okay, is that
Looks like
also
both of them are 3,500.
3,500?
Good bonds on both.
All right, and I would ask that if we're going to have a bond here, I would ask that pretrial reads the history, but as you're probably already aware, Your Honor, we're going to object to any modification. We have 2 battery family violences with the same exact victim, and I'm sure, and I don't want to misspeak, but I'm about to pull up this first bond order. I'm sure that at a minimum, it was a no further violent contact, if a no contact order, and here we are again with the same exact victim with the same exact charge. So for obvious reasons, we'll be objecting to any modification. But with that being said, I would ask that pretrial goes over the history.
Pretrial.
One moment. 20 cycles, last arrest, June of 2021 for terroristic threats and act and simple battery family violence in Richmond County, Georgia. Record indicates an open probation for those charges. Sentenced September of 2021 with 5 years probation. Case number 21R CCR 01205. 1 violation of probation within the past 10 years. I am showing a hold out of Augusta, Georgia for a violation court order, and that was issued March of this year. Also, his convictions are outside the 10-year period. They're 1999 and 1997. Nothing further to add.
Okay, Your Honor, I did have an opportunity to review that first bond order. As I suspected, there was a no further contact. Additionally, there was a stay away. The second incident, same victim, same incident location. I think I heard that he's on felony probation. He's clearly demonstrated that he is not going to follow any order of any court. Obviously, we have grave concern for the victim in both of these cases at this time. And I would ask that, considering his history, his reoffense, his defiance of the court's orders, to absolutely not modify or reduce the signature, signature bond, the surety bond. It's more than reasonable, and the bond should remain as sit, Your Honor.
Your Honor, my client has told me that his plans are to relocate to Richmond County. The alleged victim is here in Fulton County.
Is that Virginia?
No, not Virginia.
Richmond County, Georgia.
Georgia, yes.
Oh, okay.
All right, and he's how old, Miss McLeod?
I believe he's 38.
Okay.
42.
Oh, I'm
42.
sorry. Where did I 38 from? 42.
All right. Well, I'm going to continue the bonds in both cases of 3,500 surety bond. Do I need to arraign both of these?
Yes, Your Honor.
All right, well, I will go forward with the arraignment. Mr. Stevens, I'm going to formally charge you in both cases since we cannot enter or negotiate a plea at this time. I'm going to read both cases to you. Do you waive the formal reading of the accusations in both cases, Ms. McLeod?
Yes, I do, Your Honor.
All right. Mr. Stevens, in the first case, 22 CR 004303J, you're charged with 1 count of battery family violence. You've been charged in this case, which has been formally accused by the Solicitor General's office in Fulton County, and this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. This case will be reset for a jury trial. The trial will be scheduled by the state court judge to whom this case is assigned, or the division judge, as further notice for trial. Make sure you keep your address and phone number updated. And again, the second case, which is a 22 CR 004527J, again, 1 count of battery family violence with the offense date of May 24th, 2022. You have been formally charged and accused by the Solicitor General's office of Fulton County, and this charge carries a maximum sentence of 1 year in jail or a maximum fine of $1,000. For each of those 2 charges with the 2 separate cases, they can either run concurrent or consecutive, but you have been formally noticed and charged. How do you plead to each of those cases?
Guilty,
I'm sorry?
guilty.
We don't have them down as guilty. I'm arraigning you. Your attorney has not accepted the plea on this case. So how do you plead?
You're guilty,
No.
Is, again, are we taking a plea on 33 and not the add-on?
I mean, the
think
state
we-
is prepared to move
Well,
forward as the
if
defendant wishes.
he wants to take a plea, Your Honor, it really, that is his prerogative to do so if he wants to.
You understand, I'm not giving you advice and I'm not able to give you advice, Mr. Stevens. You have an attorney and you need to listen to her. I know you've heard the state mention if you take the plea on the first charge of the first case, then it will automatically be a felony and they will transfer the second charge to the DA's office. Are you prepared for that?
Mr. Stevens, do you understand that? The judge is asking you, once you take a plea on this first case, it makes your second case into a felony. So they are going to transfer it to the DA's office. So you will still be here on that unless you post bond. Do you understand that?
Yes, but I got a program that I got to get back to. So it's either way that I'm still gonna be here. I wanna go on and get this over with so I can go back to my program. One girl that stays up here, I don't even, she came and got me and then she put charges on me. That's not fair, but I just.
Mr. Stevens, we're not going to get into the facts of your case.
But I'm saying though, I want to go on and get this over with. I
understand. He wants to take the plea, Your Honor.
Are you still representing him, Ms. McLeod, if he takes the plea?
Yes, Your Honor.
Okay. All right, so you want to take a plea to the first case for battery family violence. Is that correct, Mr. Stevens?
Yes, ma'am.
All right. And you have gotten proper advice from your attorney. Is that correct?
Yes, ma'am.
All right. I will take that plea if you so choose to want to do that. And I'm going to ask you a series of questions before I can take your plea. All right. Are you under the influence presently of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney?
Yes,
Do you understand that by pleading guilty, you are giving up and waiving the right to the presumption of innocence?
yes, ma'am.
Do you understand that by pleading guilty today, you are giving up and waiving the right to remain silent and not testify against yourself?
Yes,
That you are waiving and giving up the right to trial by jury or judge, whichever you prefer?
yes,
That you're giving up and waiving the right to see, hear, and confront your accuser and all witnesses called to testify against you?
yes, ma'am.
That you're giving up and waiving the right to see and review evidence and the presence of witnesses in your favor?
Yes, ma'am.
And you're giving up and waiving the right to have the state prove the charges against you beyond a reasonable doubt?
Yes, ma'am.
And that, are you prepared again to agree to waive and give up these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes, ma'am.
So as to the charge of battering family violence in the first case ending in 303J, how do you plead?
Guilty, Your Honor.
All right, and so the terms are of this plea, and the conditions are 12 months to serve 34 days, credit for time served at 17 days, FVIP, which is a Family Violence Intervention Program, and you are to stay away from, I don't have the
It's
address.
1093 West Avenue Southwest. And the victim's name is Cherry Jones.
And I'm sorry, I had that in front of me on the.
And that
on the
is,
bond orders.
that address is located in Atlanta, Georgia, Your Honor.
Right, okay. And I'm sorry, I forgot, Mr. Walker, I had the bond orders.
It's okay, Your
in front of
Honor.
me.
We're
I'm
working
so used to
together.
asking, thank you. All right, so you have to stay away if you make bond on your other case and get out from 1093 West Avenue Southwest, or 1093 West Avenue Southwest in Atlanta, and you are to have no further contact, absolutely no contact, indirectly or directly, with Sherry Jones, or Cherry Jones, is that correct? You understand
Yes,
that, right?
That's the name.
Okay, Cherry Jones. All right, I will accept your guilty plea to that case. The other case has an existing bond of $3,500 strip bond. All right, Mr. Stevens, counsel, does that conclude our?
Thank you, Your Honor. Yes, it does.
All right, thank you. And 5 will be transferred to the DA's office. You're gonna send me a transfer, Mr. Walker?
I will, Your Honor. I will
Or
make
in
that
due
happen.
time? I understand.
Okay, we have to get, it's a procedure that I have to go through, but yes, we will be sending one in soon enough.
All right, thank you.
Your Honor, that concludes my business for today. May I be excused?
Yes, you may. See you next time.
Thank you, Judge.
Oh, hold on one second, Miss McLeod.
Yes, Judge.
Miss Champion says she needs from you the plea paperwork.
Yes,
for
I will
position.
prepare.
Yes. Okay, send it to April.champion.
I will do that, Your Honor.
All right, thank you. All right, Deputy, who do we have next?
Position 35.
And who's in the courtroom again? Oh, that's right. Okay.
And that's a non-negotiated plea, Your Honor.
Okay. I have position 35, which is case number 19 CR 002-850Y, Michael Whitfield.
That is correct. Your Honor, are you ready for me to proceed?
Yes, let me read the charge. It's a simple battery and battery, 2 charges. One with the offense date of July 18, 2018. The battery offense date is March 22nd, 2019. Go ahead, state.
Your Honor, the first incident for the simple battery occurred, like you said, on July 18, 2018. The victim, Miss Camilla Rawls. Camilla is spelled Camilla, last name Rawls. She was sitting on the front step of her apartment with a male friend, and her ex-boyfriend, the defendant, approached and began yelling at her. She told the officers that it was out of jealousy. I guess he slapped her in the face, walked off towards the abandoned building. She told the officers that he lived in that building, and that she called 911 to report her injury. The officers did search the apartment building that Ms. Rawls pointed them in the direction of, but they were unable to locate the defendant inside. But Ms. Rawls did provide a picture, I believe. Wait 1 second, I've read this one. There was something provided to the officer. He then put out he then gave her the information for, let's see, I'm sorry, Your Honor, these facts are a little bit confusing. It looks like the defendant wasn't apprehended until March 22nd, 2019. And that is when the second battery issue occurred. Your Honor, I do not have that police report in the system as of yet, but there was, like I said, a second battery that occurred at that MARTA station, and that's when he was picked up on this warrant for the simple battery from 2018. As to the criminal history, it looks like he has 13 cycles from 2007 to 2019. In the last 5 years, he's had 2019 simple battery, 2020 criminal damage to property, battery, family violence, and disorderly conduct, and obstruction. That was all in 2020. And then also another 2020 obstruction and interference with government property. The state is offering 12 months, 45 days to serve, credit for time served 10 days, the balance probated, 6 weeks anger awareness, anger management, no further violent contact with the victim, and stay away from the incident location, which is 2129 Martin Luther King Drive, Junior Drive Northwest, apartment A9. Nothing further.
All right, Ms. Helen.
Yes, Judge, this is a non-negotiated plea. Mr. Whitfield is accepting guilt in this case. The only thing that was at non-negotiated, Judge, is the jail time. We are asking for time served, again, accepting the conditions of probation. Mr. Whitfield is here for a failure to appear from February 9th of this year, Judge, as well as a second date, May 10th. When I went and spoke to him, Judge, he has moved since 2 to 3 years ago. He moved from the address that the court had updated, and currently on Odyssey is the updated address. And so, Judge, Mr. Whitfield is here for not a new charge. It is a failure to appear. There was 2 notices. I have an updated address of 7283 COSA, COOSA, Union City, Georgia, 30291. Prior to that address and him updating that address with the court, he was living in Atlanta. And so when he moved, Judge, he did not get those notices. And when I spoke to him, he had no idea that those jury trials had been scheduled and that he missed them, Judge. And so he's been confined 10 days for these failures to appear, Judge. We're asking for time served. He wants to accept the conditions and the probation and complete it, Judge. But since we are asking for probation, we are asking for at least 4 of those months of probation fees to be waived, because he has lost all employment after being arrested for these 10 days, Judge, but he does believe he'll be able to get back working.
Your Honor, just based on, like I said, the history, we've got the simple battery, and we've got the battery, family violence, we've got disorderly conduct. Just based off the history in the last 5 years, the state is objecting to the time served, and we're asking for the 45 days with credit for time served, the 10 days, which essentially would put him in custody for another 12 days, I believe. And the state feels as though it's appropriate based on the incident and the violent nature of the incident. Nothing further.
Judge, again, we're asking for we're asking for time served. Judge, Mr. Whitfield, like I said, is accepting guilt in this case. He does agree to the 6 anger management, the year probation, and then he has had no contact with Ms. Rawls, who's mentioned in the 2018 incident, and no other contact with the individual mentioned in the battery, Judge. So again, Mr. Whitfield is accepting responsibility in this case. We are asking for time served. We feel that the 45 days as a recommendation would be too much. Again, he is there for a failure to appear. I have an updated address, and we are asking for that time served plea, Judge.
How old is Mr. Whitfield?
Judge, 34.
Okay.
34.
And he's from Georgia?
Yes, Judge. Okay, so he also has a GED, Judge. He is employable, has been working for several supply chains for the last several months.
Okay. Thank you, Ms. Helen. All right, I'm going to accept the plea. I'm going to enter an order for and accept on the plea conditions credit for time served 10 days with no additional days of service. And the other conditions, as I'll read in a second, but that will be my ruling for no additional days of service, credit for time served 10 days. All right.
Understood, Judge. Mr. Whitfield, did you hear that? Thank you.
Okay, we're ready to take the plea, Mr. Whitfield. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of the attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
Do you understand that you're waiving and giving up the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're waiving and giving up the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone told you that you will receive a lesser sentence for pleading guilty?
Yes, ma'am.
Has anyone promised you anything to plead guilty? I'm sorry?
No, ma'am.
Okay. And do you understand that if you're currently on probation, your probation may be revoked because of this guilty plea today?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, so to the charge of simple battery, how do you plead?
Yes.
And as to the charge of battery, how do you plead?
Yes.
All right, and so the conditions are 12 months, 45 days, 12 months to serve, 45 days. I'm sorry, 12 months on probation, 45 days to serve, credit for time served 10 days, balance probated, 6 weeks anger awareness course. It's a 6-week course that you must complete. No further violent contact with the victim, Camilla Ross, and you are to stay away from 2129 Martin Luther King Jr. Drive, apartment. I didn't write that down. There's a particular apartment, I believe.
A9, Your Honor.
Apartment A9. So please don't go back, don't contact her, else you'll be right back here in jail again. And next time you won't get any mercy, I tell you. So do you understand those conditions? And what I'll do is I'll waive 3 months of the probation fees. All right.
And Judge, I just want to make sure I got the plea amounts correct. He's been incarcerated for 9 days. So if it's a time served plea, I think that would be served 18 days, credit for time served 9 days with the conditions of the 6 anger management, no contact with the victim and stay away from the incident location.
Yeah,
thank you for helping me with my math and the days. Yes.
Yeah, I wrote down 45 days and
she wrote time served. Judge,
oh, right.
you wrote time served?
Time served.
Right.
Okay.
And so
the time, 20 days. Okay. Okay.
All right. Do we have that right, Ms. Champion? So I don't mess that up too bad.
They served 12 months to serve 20 days, credit for time served 10 days.
Yes, did you, we all said 9, someone said 10. I thought it was 10.
Yeah, that was 10.
No? Count for me someone and help me.
I have 9 reflected on Odyssey.
I'm gonna defer either to PD Helen or Mr. Walker, because with my connectivity issues, I can't get on Odyssey right now. Your Honor.
Mr. Walker, do we have 9 or 10? He's
Your Honor,
double.
10 days is, that's fine.
Okay.
Yeah, that's fine.
Thank you, Mr. Walker.
Thank you. All right, are we all clear? Okay. All right, thank you. Good luck to you, Mr. Whitfield.
Thank
All right.
And then you number 37, Mr. Young.
Okay.
And that's a negotiated plea, Your Honor.
Have position 37, 22 CR 004104Y, James Marlon Young. You're charged with 1 count of battery, offense date June 17, 2022. And I understand this is a negotiated plea.
That is correct, Your Honor. The state is offering 12 months, 38 days to serve, credit for time served 19 days, balance probated, 12-week anger awareness, and no further contact with the victim, and a stay away from the incident location, which is, it looks like there's 2 incident locations. It looks like 418 Lovejoy Street, Northwest, Unit 103. And then it looks like, based on the police report, there was also something that may have transpired at 100 Mill Street. It just says near the Atlanta Mission Homeless Shelter. So I don't know exactly what that location is, but those are the 2 addresses.
Okay. And who's the victim? No further contact?
Chandra Norman. Chandra is spelled CHRANDA, and Norman is common spelling.
All right.
Yes, Judge, that's our understanding of the plea. We do stipulate to the factual basis, venue, and ID. It is a probated sentence, so Judge, we are asking for those first 4 months of probation fees to be waived until Mr. Worthens can get on his feet. He also is residentially challenged, so I'm actually going to ask for all of the probation fees to be waived.
All right, I will waive 6 months of the probation fees. All right. And so, Mr. Young, are you ready to enter your plea?
Yes, ma'am.
And you stipulated, Ms. Helen?
Yes, Your Honor, I did.
All right, raise your right hand for me, Mr. Young. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, at this time, are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
You put your hand down. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charges against you?
Yes, ma'am.
All right, and as to the charge of battery, how do you plead?
Guilty.
All right, I will accept your guilty plea. The conditions of your plea are 12 months probation to serve 38 days, credit for time served 19 days, balance probated, a 12-week anger awareness course, no further contact with Chandra Norman, and to stay away from 418 Lovejoy Street Northwest, unit number 103, as well as to stay away from 100 Mill Street near the Atlanta Union Mission. So are you aware of where you should not go? What
Yes,
you
ma'am.
should go? All right, govern yourself accordingly on that, because you'll be right back down here in the Fulton County Jail. So just stay away from those areas, okay?
Yes, ma'am.
All right, counsel, anything else you need to take up?
No, Your Honor.
Oh, did I also say 6 months waiver of the probation fees? I'm sorry.
Yes, Judge.
Sorry. All right, that should conclude this case.
Yes, yes. Good afternoon, good morning, Your Honor. This is the South Annex.
Yes.
Before you is position 15 and 16, Miss Alicia Johnson.
Thank you.
And this is a negotiated plea, Judge.
All right. The first case I have for Miss Alicia Johnson is 17 CR 018795Y. I have 5 charges. The first one being failure to maintain lane, failure to report striking a fixed object, failure to have license on person, reckless driving, and DUI under the influence of alcohol less safe, all with the offense date of February the 6th, 2016. I have the second case, 21 CR 007054F. I have 8 charges. The first one being knowing and driving a motor vehicle on a suspended, canceled, or revoked registration, possession of marijuana less than an ounce, failure to yield to right of way at a crosswalk, possession of open alcohol container, reckless driving, DUI under the influence of alcohol and drugs, DUI under the influence of alcohol as safe, and DUI driving under the influence of alcohol per se. And I know this is a global offer. And State, you may proceed.
Yes, Your Honor, for position 15, is to be a guilty plea on a DUI less safe, 12 months to serve 14 days, credit for time served 7 days with the balance probated, $1,000 fine, 240 hours of community service, alcohol and drug evaluation and treatment, risk reduction, and victim impact panel. We will be null processing the other charges on position 15. For position 16, the guilty plea will be for DUI per se, 12 months to serve 7 days, credit for time served 7 days with the balance probated, a $1,000 fine, 240 hours of community service, alcohol, drug evaluation and treatment, risk reduction, no drugs or alcohol, and a victim impact panel. There's also a 12 additional months of probation for the fail to yield to be served consecutively. We'll be null processing the other charges outside of those.
Okay.
And that is our, oh, sorry.
So that would be 24 months of probation?
That's correct, Your Honor.
Okay, go ahead, Mr. Finley.
Yes, Judge, that is our understanding of the offer, of which we do agree. Ms. Johnson has agreed to each of those conditions. We would just ask that the probation fees could be waived for a period of time, just so it helped a little bit as she's already paying the fine. And we stipulate the factual basis, venue and ID, Judge.
All right. All right, Ms. Johnson, I'm ready to accept your plea, but I'm going to ask you some questions as we do that. Can you raise your right hand? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth, and that the penalty of perjury?
Yes, ma'am.
All right, as to, the first case, which ends in 795Y, you're pleading guilty, to the DUI, let's say. And that is it, and the rest of the charges will be no pros. Is that correct?
Yes, Your Honor.
Okay, and so let me ask you this, are you under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up or waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up or waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
That you're giving up and waiving the right to remain, that you're giving up and waiving the right to a trial by judge or jury, whichever you prefer.
Yeah.
I'm sorry?
Yes, ma'am.
All right, are you prepared and agree to waive these rights today?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am.
As to the charge of DUI, driving under the influence of alcohol, less safe, how do you plead?
Guilty.
All right, and so for that guilty plea to the offense date of February the 6th, 2016, that will be 12 months probation, to serve 14 days, credit for time served 7 days, balance probated, $1,000 fine, 240 hours of community service, ADET, risk reduction, and a VIP victim impact panel. Is that everyone's understanding? And so you've got to complete all of these conditions. It's gonna run concurrent with your other, consecutive, so that you will technically be on probation for 24 months, 12 months for this case and 12 for the second case. Ready for the second case? All right, the second case ending in 7054F, and you're pleading guilty to DUI per se, and a consecutive case on failure to yield. Is that correct?
Yes, Your Honor, the DUI per se and the failure to yield. Yes, Your Honor.
Right, and then all the other charges will bring no cross. Is that correct?
That is correct.
All right, and so for the second case ending in 54F, that pleading guilty to the DUI per se is 12 months probation to serve 7 days, credit for time served 7 days, balance probated, a $1,000 fine, 240 hours of community service, ADET, risk reduction, and RS, and no victim, or yes, a victim impact panel. I'm making sure I understand the abbreviations. I know RR is risk reduction. What's RS?
Oh, random drug screens and alcohol.
Thank you. Okay, I was trying to think very hard. The harder I was thinking, the worse I was coming up with the response. All right, so you're going to be subject to random screening, and no drugs, alcohol, or weapons while on probation. And you're to do, so she'll be doing 2 victim impact panels. Is that correct?
That's correct, Your Honor.
All right, and then you have the 12 additional months with probation running consecutively with failure to yield, and then the other charges on your second case will be no crossed or dismissed. Do you understand this, Ms. Johnson, and these conditions for your plea? And Mr. Finley?
Yes, sir.
Okay.
Yes, Judge.
All right, so you've got a lot to do, and I'm going to waive 6 months of your probation fees so that you can get all these things done.
I have a question, Your Honor.
Yes.
When I talked earlier, I already had completed the risk reduction classes and stuff when I had talked with him, and
they told me that you was possibly was gonna give me those classes. So I had already completed the risk reduction and the alcohol and drug evaluation,
Okay,
but I only did 40 hours of community service.
okay. Well, as long as by the time you're finished with probation, you have done those with your 24 months. So those would count as far as I know. Is that correct, Madam Prosecutor?
Yes, Your Honor, as long as they are after the incident date, they will all count.
Right, as long as they were taken after the incident date, then those conditions, you give those certificates to your attorney, Mr. Finley, and he will make sure that the state has those, or probation will have those, so that you will get credit for those courses that you've taken and for the 40 hours, but you got another 200 to go. Actually, she's got another 440 to go, right? Yes, we have another, they're making me do some big math here today. Another 440 hours of community service. Is
Well,
that-
Your Honor, I'm coming on the tail end. It should only be 240 hours of community service.
Oh, because they're running consecutive. No?
That
I
was
thought it was
as far as the community service, that was meant to run concurrent.
concurrent. Thank you.
If
Okay.
there's other conditions, it's a consecutive sentence, but that particular condition should be concurrent if it's on there twice.
Okay,
Is what
all
I'm
right,
trying to
so I
say.
got that wrong. The community service runs concurrent, and so you would only have 200 more hours of community service.
And the fine will be concurrent as well, Your Honor.
Okay, gotcha. Mr. Finley understands, I am sure.
Yeah.
Listen to your attorney, and he will get it correct. Because I'm doing a lot of pleas today, so I don't want to mess them up too bad, but for the record, it is only 240 hours of community service, and one risk reduction class, one ADET, and you will have to do 200 more hours if you've already done 40.
Okay.
Okay?
Yes, ma'am.
All right, don't want to confuse you. All right, is there anything else I need to take up with this plea?
From the state, Your Honor.
Nothing further, Judge. Thank you.
All right, thank you. Good luck to you, Ms. Jackson. I'm sorry, I called you by the wrong name, Ms. Johnson. All right, that will conclude your case. Thank you.
Next, we have position 19, Ms. Kirby.
And this is a negotiated plea, Judge.
All right, Miss Amber Kirby, this is case number 22 CR 004133A, and you're charged with one count of theft by shoplifting. The offense date is May 28, 2022. State?
Yes, Your Honor, I'm sorry, somebody.
Hi,
It's 12
no. Ms. King, are you go forward if you want to, that's totally fine.
Oh, it was yours, I'm sorry.
No, it's totally fine. Your Honor, the offer was it was 12 months, 32 days to serve, credit for time served, 32 days, balance probated, a theft class, a stay away from the incident location, and no contact.
Okay.
Yes.
Can you give me the address and the victim?
The address, Your Honor, the address is 2097 Main Street in East Point, Georgia. That's actually a CVS store. And so the no further contact, I guess the stay away will take care of him staying away from the incident, and the employees there. So the stay away is fine. You can remove the no further contact.
Okay. All right. Mr. Finley?
Yes, Judge. That is our understanding of the offer, of which we do agree. I would just ask on behalf of Ms. Kirby that once she does complete that theft class, that the balance of her probation could be terminated, as that's the only condition or the kind of class or whatever that she has to do.
State have any objections to terminating upon completion of the theft class?
Honestly, Your Honor, no. Well, Your Honor, I will object to that simply because based on the history, she does have a theft by shoplifting NOLO in 2019. And so this was in 2020. So I would say that after, I would object to that, Your Honor, just based on the history. She's got 16 cycles and several theft charges. And so, the state objects.
All right.
And Judge, I would just state that, she only has the theft class. And I just know on a lot of these theft by shopliftings, the balance is a lot of times suspended once they finish that, as it's kind of, there's usually just that theft class that goes hand in hand with these theft by shopliftings. And that's the only condition that she has to complete other than the stay away.
Well, I will allow her to go non-reporting after the theft class, but I want to keep her on 12 months probation, that she can go non-reporting after the theft class.
That works good.
Okay.
That works, Judge. Thank you.
So, Ms. Kirby, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am, Your Honor.
All right, I need to ask you a series of questions to take your plea. Are you under the influence of any medication, drugs, or alcohol at this time?
No, Your Honor.
Are you satisfied with the services and representation of your attorney?
Yes, Your Honor.
You can put your hand down. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, Your Honor.
That you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Has anyone told you that you receive a lesser sentence for pleading guilty?
No, Your Honor.
Has anyone promised you anything to plead guilty?
No, Your Honor.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, Your Honor.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, Your Honor.
And as to the charge of theft by shoplifting, how do you plead?
Guilty.
All right, I will accept that. Your conditions for 12 months on probation to serve 32 days, credit for time served, 32 days, balance is probated. You are to take a theft class to stay away from 2097 Main Street in East Point, which is the CVS. Once you complete the theft class, you can go non-reporting, but you will still be on probation for the 12 months, but you don't have to report after that.
Thank you, Your Honor.
All right, and that will conclude this case.
Thank you.
Next, we have position 20, Ms. Lester.
And this is a negotiated plea, Judge.
All right. Hold on 1 second. We don't, excuse me, state, we don't have the recommendation of Mr.
I have it, Your Honor. The state's recommendation is it's a time served offer. I believe the defendant has been in custody for 43 days. Balance suspended.
50 days.
Okay, I'm sorry, 50, however many days is time served. Balance suspended with the conditions of a stay away from the Walmart located on 844 Cleveland Avenue.
You'll probably have to tell me more because I don't even have it on my calendar. I have it on the rec sheet, but it did not make my calendar.
Yes, give me 1 second.
Look at your calendar. I think we all have the same one. I don't have that case at all.
Correct. Let me pull it up in Odyssey and I can give you the case number and
Okay.
this is Patricia Ann Lester, case number 19 CR 006961B. She is charged with 1 count of theft by shoplifting with an offense date of 2/14/18. The state's recommendation is time served. Let me check. I'm pretty sure the jail screen shows 43 days, but nonetheless, it's time served, bound suspended with the stay away condition of Walmart, 844 Cleveland Avenue.
And no theft class, right?
Correct, due to the time.
Okay.
And the age of the case.
Okay. All right, this is position number 20, Patricia Lester. Case number is 19 CR 006961D. Is that correct?
That is correct. And she's been in custody 49 days, Your Honor.
49, okay. And the charge is theft by shoplifting with the offense date of February the 14th, 2018. And this is going to be a negotiated plea, credit for time served. Mr. Walker just read the conditions. And Ms. Lester, I'm going to ask you a series of questions before accepting your plea, okay? Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Are you presently under the influence of any medication, drugs, or alcohol?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
You put your hand down for me. Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
Do you agree that by pleading guilty today, you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
Do you agree that by pleading guilty today, you are giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And has anyone promised you anything to plead guilty today?
No, ma'am.
Has anyone told you that you'll receive a lesser sentence for pleading guilty today?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Yes, ma'am, but I'm not.
Okay. Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, I will accept your plea to the charge of theft by shoplifting. How do you plead?
Guilty.
Okay, all right, and you heard the conditions, 12 months probation, credit for time served at 49 days, balance suspended, and the only other condition is that you stay away from the Walmart on Cleveland Avenue. If you go back there, they're gonna recognize you and call the police to have you arrested again. So
And Your Honor, I just want to make sure I heard correctly. That was balance suspended, correct?
balance suspended, yes.
Okay, thank you.
Right, and so this is a credit for time served, but you'll be right back in jail if you go over to the Walmart again while you're on probation, okay?
I'm gonna be on probation.
Well, the balance is, I'm sorry, balance is suspended. So I'm sorry, I said that incorrect. Since the balance is suspended, technically you could go back, but maybe you should do a cooling off period.
Well, no, you still can have a condition on a suspended sentence. So the condition to the suspended sentence is the stay away.
And I think, are you asking me how long you have to stay away? For the remaining of the 12 months?
Correct.
Right, right, for the remaining of the 12 months. So you cannot go back, even though your probation is suspended and you don't have to do any other conditions. The one term for that is to not go back to the Walmart for 12 months.
Okay.
Okay? Have I confused you or do you understand?
Well, I don't go to that Walmart anymore anyway, and that's been since 2017.
Okay, well, that is
February
good.
14, 2017, I've not been back there.
Good. Well, don't go back for another 12 months just to be on the safe side, of 13 months, okay?
Okay.
All right, good. Good luck to you.
Okay.
All right.
Next, we have position 36, Ms. Wharton.
That's a negotiated plea, Your Honor.
Thank you. All right, this is 22 CR 004328Y. Jasmine Worthing. You're charged with 1 count of simple battery, offense date July the 5th, 2022. State?
Yes, Your Honor. On this case, the state's offer is 12 months, 30 days to serve, credit for time served, 15 days, balance probated, 6-week anger awareness, no further contact with the victim, who is Candace and Brady, and a stay away from the incident location, which is 80 Jesse Hill Jr. Drive Southeast, and no alcohol, drugs, or weapons. Nothing further from the state.
Yes, Your Honor, that is our understanding of that plea. We do accept it. We stipulate to the factual basis, venue, and ID. This is a probated sentence, so we are asking for those first 6 months of those probation fees to be waived. She is residentially challenged and does not have a job currently because of being incarcerated, Judge.
Is that a business at 80 Jesse Hill Jr. Drive?
That's a hospital, Judge, and Miss Candace Brady is one of the nurses there.
The nurse is at Grady.
I thought the address sounded familiar. I will waive 6 months of the probation fees.
I have to stay away from Grady Hospital.
Oh, hold on, Miss Worthings. We're just gonna let the judge speak real quick here.
Okay.
Yes, you do.
Well, normally, Judge,
We'll
you allow
say
them to
unless she's-
return if they're seeking treatment for a condition, but no, she cannot hang around Grady Hospital otherwise.
Did you hear that, Miss Worthings?
So we want to make sure that if you go back to Grady, that you do not assault or harm anybody, whether it's an employee or another patient or anyone at Grady, then you'll be arrested again. You can only go back there if you're receiving treatment or you have a doctor's appointment. If you don't, then you should not be at Grady.
Thank you.
Okay, so I'm going to accept your guilty plea, and we will get started with that so that you understand. You also have some other conditions of taking a 6-week anger awareness course. Okay, and so you'll get that information from your attorney of how to do that. So make sure you do that as well. You'd have no further contact with Candace Brady, and no drugs, alcohol, or weapons while on probation, okay?
And Judge, we are asking for the first 6 months of the probation fees to be waived.
Yes, I will waive the first 6 months of probation fees. All right, so again, this case is with Jasmine Worthing, 22 CR 004328Y, 1 count of simple battery. Ms. Worthing, let me ask you a few questions. And I need to have you to raise your right hand for me. Do you affirm that the testimony about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
Are you currently under the influence of any medication, drugs, or alcohol?
No, ma'am.
You put your hand down. Are you satisfied with the services and representation of your attorney?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, ma'am.
That you're giving up and waiving the right to remain silent and not testify against yourself?
Yes, ma'am.
And that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
Has anyone told you that you will receive a lesser sentence for pleading guilty?
No, ma'am.
Has anyone promised you anything to plead guilty?
No, ma'am.
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here?
Yes, ma'am.
And do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes, ma'am.
All right, as to the charge of simple battery, how do you plead?
Yes, ma'am.
Okay, and so again, the terms of the plea, and the conditions are 12 months probation to serve 30 days, credit for time served at 15 days, balance probated. You're to take a 6-week anger awareness course. You're to have no further contact with Candace and Brady. You're to stay away from Grady Hospital at 80 Jesse Hill Junior Drive Southeast unless you're receiving treatment. You're not to hang out there for any other reasons. And no drugs, alcohol, or weapons while you're on this 12 months probation. I will also waive 6 months of the probation fees. All right, any questions?
No, Your Honor.
Thank you, Your Honor.
Yes, good luck to you, Ms. Worthman.
Thank you, Judge.
Okay.
That's it from the South Annex, Your Honor.
Thank you. Have a good one. Bye-bye.
Oh, Your Honor, I have 2 more people who are supposed to be at South Phoenix. Miss Nakia Parker, who's on the add-on, and then also Miss Benny Stamps, who's.
So you've had some people to bond out, Deputy?
Yes, we had 2. Miss Herswick, position 13. Have a seat over there.
13.
And 11, both of them were released.
And Judge, I have an add-on calendar that mentions Miss Nakia Parker as supposed to have in court today or appearing today. I also have a Benny Sams who has a time served deal. She's supposed to appear today. Miss Sams is position. She's position 27 on the SAP calendar. And then Miss Parker is positions 3 and 4 on the add-on calendar.
Miss Sams is at medical, excuse me, is in medical at Rice Street. And who is the other one?
Miss Nakia, N-Y-K-I-A Parker.
Number 4 on the add-on. 3 and 4.
Yes.
Nakia Parker.
May I have her booking number, please?
Sure, I got a booking. Her booking number is 2210347.
Give me a minute and I will go get her for you.
Thank you, Officer Milne.
Okay, thank you.
Your Honor, are we on the add-on calendar for position 2?
What was the question?
Right, and so there was a mistake. She was on the add-on calendar originally, but the jail said that they forgot to update the system, but she was released on 6/18. So I just wanted to make sure that the court had that information as well.
Okay, that's Antoinette Glenn.
Yes.
Okay, so she's been released. Okay.
Thank you.
Good.
Is there an announcement on position 4 on the regular calendar?
Also, I don't know about position 1. I have 1, 4, and 5. And 6, and I've got a lot. I only see 1 in courtroom 2. Who is that in courtroom 2?
That's position 26.
That's Mr. Samples.
Yes.
Okay. I guess, is that all you have?
Yes.
Second and third row.
Yeah, Judge.
Okay. So I guess the other ones we're going to assume, unless you tell me otherwise, I've got about 3 or 4. I'm assuming they've been released. Or are you bringing in more?
What position?
Position 1, Michael Beecham.
Okay.
Mr. Beecham is a
loan out.
He's a loan out.
Loan out?
He's not-
Okay.
He's not there.
I think someone might tell me reading is fundamental here, but I'm catching up. Let's see, 4 has been released, okay. And then who else? Position 5 says hold for announcement.
Yep.
He refused to come out. Travis Clark.
Yeah, they were.
Refused to come out.
Okay.
Yeah.
Oh, 6 was a felony transfer.
Yes.
Okay. Someone sending me an order? Or has it already been done?
I haven't received an order.
We haven't received an order yet on 6. Robin Cox, that's a felony transfer. Someone gonna get me that?
Yes, Your Honor.
And then what about 7? 7 transfer to the composite calendar, do not bring, okay.
How about position 34? Cassius Wells?
He's been released. There was a message in the chat that said he was released on June 19th.
Oh, I see it now. That's actually 37.
It's actually 34.
Oh, nope, it's not that. 34?
34.
34 has been released, okay. And 27.
It was a medical reset, is that correct?
That is correct. And Judge, can we do 1 week? I'd like to reset it for July the 26th.
Okay.
Is there any
I
other?
saw one other. Oh, I see. 29 is reset to 7/26. Okay.
That's correct, Judge.
$28. Let's see. 7. Did we do 28?
28 was a negotiated plea, Your Honor.
It was correct.
Anything else, Ms. Champion, that I've missed?
Position 17?
17?
Or maybe I missed something with that one.
Nope, I don't have any.
Oh,
Jail
the jail said that she refused to come out. So,
refused to come out on 17.
yeah, so if we could reset her a week, please.
Okay, she's gonna be reset for 7/26.
And position 1 was reset to what day?
And Judge, I just want to make sure, did you also have a DV calendar?
That's what I was just about to
I
say.
do, and I have a patient person in the courtroom, one for that calendar, so please bear with me, we're getting there. We're almost with you, yes, I do have them in the courtroom. One other one, position, what was the other one, Ms. Champion? Oh, position 1, you want it reset to what day? Or do we know?
Position 1.
That's the one that's loaned out,
Yeah. Could we do 2 weeks on that one?
okay?
So I guess that would be
August the
the
2nd,
2nd. Yeah, the 2nd, please.
okay? Okay, we'll go ahead with position 26. Is that what I have before me?
Yes, Courtroom Two.
Thank you. Mr. Samples?
Yes, Your Honor.
Okay, this is 19 CR 0075224C. Jesse Samples, charged with laundering or prowling. The offense date 6/28/2019. State.
Your Honor, the offer on this one is 12 months, 34 days to serve, credit for time served 17 days, balance suspended, and stay away from the incident location, which is 2471 Old National Highway and 5010 Old National Highway.
Are those businesses or how?
It looks like the Ramada Inn is the 5010 Old National Highway and the Travel Lodge Hotel is the 2471 Old National Highway.
Okay.
Yes, Your Honor, that is our understanding of that plea offer. We do accept it. We do stipulate to the factual basis, venue, and ID.
All right, Mr. Samples, raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, you put your hand down for me. I'm gonna ask you a few questions in order to accept your plea. Are you presently under the influence of any medication, drugs, or alcohol?
No, I'm not.
Are you satisfied with the services and representation of your attorney? I think they muted you. Are you
Yes, I am.
satisfied with the services and representation of your attorney?
Yes, I am.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, Your Honor.
Do you understand that you're giving up and waiving the right to remain silent and not testify against yourself?
Yes.
Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer? Yes. I can't hear you. Can you hear me, Mr. Sam? Uh-oh, I think we froze. Okay, there you go. Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer? Can you hear me, Mr. Sample?
Yes, off and on.
Okay. Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, Your Honor.
Okay. And are you, has anyone told you that you'll receive a lesser sentence for pleading guilty today?
Yes.
Has anyone promised you anything to plead guilty today?
Ma'am?
Has anyone promised you anything to plead guilty today?
No. Yes,
No?
Oh.
Has anyone promised you anything to plead guilty today?
Yes, Your Honor.
Can you hear my question? You're not giving me the proper answer. Has anyone promised you anything to plead guilty today?
No, Your Honor.
Okay. And has anyone told you that you'll get a lesser sentence if you plead guilty today?
No, Your Honor.
Okay. And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today? Do you understand that, if that's the case?
I couldn't hear you.
Do you understand that if you're currently on probation, your probation may be revoked because of a guilty plea here today?
Oh, yes, Your Honor.
Okay. And so do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes, Your Honor.
Okay. And so to the charge of laundering and prowling, how do you plead? To the charge of laundering and prowling, how do you plead?
Guilty.
Okay. All right. Thank you. I'm sorry we're having a little bit of technical difficulties there. All right. So you do understand, Mr. Sample, that you have 12 months probation, 34 days to serve, but credit for 17 days already served, balance suspended, and you're to stay away from the Travel Lodge at 2471 Old National, and you're to stay away from the Ramada Inn at 5010 Old National. You stay away from both of those places, or else you'll be rearrested. You understand?
Yes, Your Honor.
Okay, stay away. Cannot go back there. All right, anything else, counsel?
Nothing further.
All
No,
right,
Judge.
all right, thank you. Okay,
She's there.
oh, there she is. Just came back. All right. South Annex.
Yes, Your Honor. FYI, position 27. She is here at the South Annex, but she's under quarantine.
Okay, I think we did have a medical, right? We reset her to July 26th.
Not you, not you.
No, for 27. And so this is Ms. Parker.
Oh, no, Judge, you were right. Next Tuesday, the 26th.
Oh, okay. So, and I have before me again, Deputy.
Miss Parker, Nakia Parker.
I thought so, okay.
And this is a negotiated plea, Your Honor.
All right, this is case number 20 CR 003344Y. Nakia Parker, you're charged with 1 count of battery family violence with the offense date of May 18, 2020. State.
Yes, Your Honor. The global resolution is 12 months to serve 20 days, credit for time served 10 days with the balance probated. The Family Violence Intervention Program, no further contact and stay away. The state also asks there's no early termination of the probation.
All right, and I have a second case, 21 CR 005797Y. The charge is disorderly conduct with the offense date of 10/26/2021. What is that? Please?
That is 12 months to serve 10 days, credit for time served 10 days with the balance prorated. A Family Violence Intervention Program, no further contact and stay away, and no early termination of the probation. Those cases have 2 different victims. The victim in the first case is Aisha Parker, her mother, IASHA, same last name as the defendant. In the second case is Miss Jerika Greer, GEREKA, GRIER. And the incident locations are different for the stayaways. For the first is 256 Glen Street Southwest. For the second is 637 Pryor Street Southwest.
And Judge, that is our understanding of the plea. We do have her mother, Aisha Parker, on the line. I wanted her to show it is negotiated to state if she would like no further contact or no violent contact. This is her mother, so I wanted her to show and state what she wanted to the court. Hi, Ms. Parker.
How you doing? I
Hold on a second. Hold on 1 second. Slow down 1 quick second for me. Raise, I can't hear you. Okay, great. Okay.
Amelia, you got to be quiet. How you doing, Your Honor?
I'm fine. How are you?
I'm fine. That's Nakia's baby.
Right.
That's her baby in the background. I'm gonna go where you can only hear me. She following me. I'm sorry. No, Amelia, go back. You can't follow her. I'm on the phone.
Okay.
I'm sorry.
That's okay. I was going to say hello, but that will probably start her to really talking, so I won't say that.
Because she talking mile a minute.
I hear you. Let me swear you in real quick. Before you start. Do you affirm the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. Tell me quickly what you'd like to tell me.
I don't want no violence. I don't want to stay. I want to stay away to go away. I just don't want no violent contact because I be wanting to see my grandbaby and stuff. I miss my daughter.
Mm-hmm. So your daughter and granddaughter live with you?
Well, they was living with my grandmama, but she been staying with her boyfriend. But I have the baby.
Mm-hmm. And so
but
you want Nakia to come back and forth. So that you can see your grandchild.
Yeah, and I basically have the baby most of the time because I don't want my grandbaby, just in different places. So, and I don't want my daughter in different places. She's done the whole turnaround. I don't know what happened last year, but with me, she's been doing wonderful. I've been contacting her. She haven't contacted me because I've been wanting to see my grandbaby, and I had to go through different people to get my grandbaby, and I miss my daughter. My daughter go through something because she have medical illness. She's so I just was trying to get her help with her mental illness. Because it's programs out here, and at the time, Nakia wasn't on any medicine when she did that. And I was asking the officer to take her to the mental facility. I had gave him all her paperwork from her being inside of, she had been to a couple of facilities.
Okay. Well,
mental
I
facility.
applaud you for trying to help her and to help your grandchild. Are you in fear of Miss Parker?
No, ma'am.
Okay. And so continue to be grandma and help her, and hopefully she'll reach out to you for that help and will allow you to continue to help her and your grandchild. How old is the granddaughter?
She's 3. And I just, yes, I want her to come home and I want her to bring my grandbaby home. I miss them. And my kids, she's trying to do better. She's been trying to do nails. I be watching her page. She trying to do hair.
Okay.
She's going to school. She's I know that she was in At Promise. She's still with At Promise. She's in a program and they're helping her. So I see the change and I see the growth in her. And
she's young. How old is Nakia?
She's 20. She'll be 21 October 1st.
Right.
She's
So
never
she's
been.
young.
Yeah, she's young and I've always had to be there for her because it's just me. She don't have anyone but me. Her father's deceased. Her grandmother's on her father's side is deceased, and we don't know where the other family members are.
Okay.
So she just don't have anyone but me.
Well, Nakia's
And
lucky
my
to have
mom.
you. She's lucky to have you, and I hope she embraces it and allows you to help her. We're going to accept her plea.
Your Honor, before you rule, I would like to put on the record that there's an open felony case against her mother as well, 20 CP 195794, which is subsequent to the case that's before Your Honor today for aggravated stalking, Your Honor. So the state would object to contact and would ask for the stay away, Your Honor.
And Your Honor, we understand the state's position, but again, it was subsequent. Ms. Parker is here. She's trying to do her best to get that bond condition of no violent contact change, and just inform the court of what's going on.
Okay, but the problem is the court is not going to rule or give a sentence that's going to put her directly in violation of a current bond order of Superior Court. That makes no sense. She has an open aggravated stalking case with no
Against who? Me?
Ma'am, yes. So
I didn't know that.
The state is not, yes. I mean, I can't speak for the court, so pardon me, Your Honor, but obviously there's a felony case with a no contact order. I can give the court that case number, but that is the basis for the no contact order. I understand that it's your mother, but we have a Superior Court case at play, which I would say would trump this case, and she's still out on bond on that case with the no contact order. So by issuing a different order, it will only cause confusion.
Right. I hope you understand, Ms. Parker.
I don't know. I
when
didn't take
you have
stalking.
listen to me for a second. Listen to me for a second. When you have a felony case pending with bond conditions to stay away, if I were to say in my misdemeanor case that she can come around, she will be locked up based on the conditions and the violations of the felony.
I don't want her locked up.
Exactly. So that's what I'm saying. My hands are a little tied on that, and I did not know that. So I appreciate the state for bringing that to my attention, because we only want the best for your daughter and your granddaughter, your grandchildren. So we cannot allow her to come around you. So
I have to just keep doing, like, go through other people to get the baby like I've been doing?
Correct. Okay.
Okay.
And so until we get these cases resolved in some manner, and get these bond conditions resolved somehow with the cases, we've got to continue with the no further contact right now.
I understand, and that's fine. That's fine.
All right, so that's what we're gonna have to do. I'm gonna accept your daughter's plea, but it will be no further contact with you. And please be very careful, because I know it's difficult as grandma and mom that you want to see her and go around her, but you know, you just got to stay away. She understands, I'm sure, because we don't want her to have to go back to jail for violating it.
Right, and I don't want her to go back either. So I won't contact her because she haven't violated. I'm contacting her because I've been wanting to see my grandbaby.
Right. But
So I'll
we're
just
gonna
go
ask,
through the third party.
yeah, ask that your daughter pick a third party. Please let grandma see grandbaby, and go through a third party, a cousin, you know, some friend or someone else, and do the exchange, okay?
I understand.
Okay.
Thank you
right.
all.
Yeah, good luck to you. So Nakia, let's do your plea. You're ready for that? I'm going to ask you a few questions. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
All right. Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes.
That you understand that by pleading guilty, that you're giving up or waiving the right to remain silent and not testify against yourself?
Yes.
Do you understand that you're giving up or waiving the right to trial by judge or jury, whichever you prefer?
Yes, ma'am.
And do you understand that you are prepared to waive these rights today?
What you say again?
Are you prepared and agree to waive these rights today?
Yes.
Okay, and has anyone told you that you will receive a lesser sentence for pleading guilty today?
No, ma'am.
Has anyone promised you anything to plead guilty today?
No.
And do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today?
Can you say that one more time?
Do you understand that if you're currently on probation, your probation may be revoked because of your guilty plea here today? I don't know that you are, but it could affect it.
I don't know what that means.
Your Honor, I didn't see that she was on probation.
And I'm saying if you're on probation. I just have to inform you of your rights.
Oh, yeah, I understand.
Okay, so if you're not, then it won't affect it, okay? And do you offer this guilty plea freely and voluntarily with a full understanding of the charge against you?
Yes.
To the charge of battery, family violence, how do you plead?
Guilty.
All right, and so remember now, the conditions are, and we've got two cases here. And then the second case, I will go over with you in 1 second. But with the battery family violence, is 12 months probation to serve 20 days, but you're getting credit for time served of 10 days. The balance will be probated. You have to do a FVIP, which is a family violence intervention program. You also have to have no further contact with the victim, who is your mother, Aisha Parker.
I can do that.
Okay, and you are to stay away from 256 Glen Street. Is that your mom's address?
Yes, ma'am.
Okay, and so it's not going to terminate early, so you'll be on probation for 12 months, okay?
Yes.
All right, let's do your second case for the disorderly conduct. On the second case ending in the 797Y. Again, I have to do this legally. I have to ask you the same questions again for a whole different case and a different victim. Are you presently under the influence of any medication, drugs, or alcohol at this time?
No, ma'am.
Are you satisfied with the services and representation of your attorney?
Yes.
Do you understand that by pleading guilty, you're giving up and waiving the right to the presumption of innocence?
Yes, I understand.
Okay, that you're giving up and waiving the right to remain silent and not testify against yourself? You
Yes.
give that right. Yeah, you have to say it. You can't shake your head.
Yes.
Okay, because we have a court reporter here. She has to take down everything. Do you understand that you're giving up and waiving the right to trial by judge or jury, whichever you prefer?
Yes, I understand.
Okay, and again, has anyone told you that you will receive a lesser sentence for pleading guilty today?
No.
Has anyone promised you anything to plead guilty today?
No.
Do you understand that if you're currently on probation, your probation could be revoked because of your guilty plea?
Yes, I understand.
Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
All right, so how do you plead to the charge of disorderly conduct?
Guilty.
All right, so again, 12 months to serve, 10 days, credit for time served, 10 days, balance probated. Again, the FVIP, no further contact with this victim, Jerika Greer, and you're to stay away from 637 Pryor Street, no early termination. So you've got two cases running there against different victims, but you need to stay away from both of them, okay?
Yes.
All right, is that clear with both counsel?
And Judge, that case is probated. We are asking for waiver of the first 6 months from Ms. Parker. She's not employed, and so we want to.
I will waive the first 6 months of probation.
Thank you, Judge. Nothing further.
All right, anything else from the state?
Nothing further, Your Honor.
All right. All right, good luck to you all, and thank you, Ms. Parker, for getting on. And take care of the grandbaby.
Okay, so see you later.
See you later.
Bye-bye. All right. Anything else?
No, Judge.
Okay. Anyone else at the annex?
Except for Miss Benny Sams. So do you want me to go and get her?
If it's possible for them to get Miss Sams, that's great.
Is she gonna be getting out?
Yes, it's a time served.
Okay, give me a minute and I'll go get her.
Thank you, Officer Milton. And Judge, I do believe that's the bench warrant case in the court. When I tried to contact him, there was no contact number listed, and the email address came back as a non-responsive email address. So if I could get a breakout session with Mr. Daquan Reed Hayes.
He's gonna have to give you a call because he's sitting in the courtroom.
Right, he's sitting in the courtrooms. You can't do a breakout. That wouldn't be confidential. So he'll have to call you, or you can call.
Or I can get his number.
Do you have a cell phone on you?
Yeah, I gave them my actual email address when I came here last week.
Well, and who is this?
Hi,
Bill
I'm Shannon Cagle. I represent from Cagle Bonding. We're on his bond. If they're needing to speak with him, they're more than welcome to call my cell phone. I can
Okay. The bonding company is here. You can call the cell phone to speak with him through the bonding company.
Sure. What's her number?
I guess we'll have to. Oh.
It's 678.
678.
334.
334.
0373.
0373.
Thank you, Your Honor.
Calling now.
Okay. So you can step back there and talk. We can go over the calendar. Well, Miss Helen, do you want to listen? She's gonna be talking.
I'll be in a phone call with Mr. Reed. If Mr. Finling could
he can get the notes and pass them along.
I can do that.
Okay.
Position number 1 is reset to the SAT. Position number 2 was a plea.
Can you check to see if that mic is on? In
Oh,
front
hold
of-
on, it may not be.
Or pull it closer.
Can she? I don't know. I don't move things in here because everything comes in. You'll learn luck with that, Mr. Jordan.
It should be a green light showing on it if it's turned on. If
You don't see the green light? Okay.
Press the little button in front of it. There should be a button in front of that mic.
The mic that's on my desk, Michael?
Yeah. Press.
Not, but it's sort of like a little thumb thing. Let's see.
If not, you can use the one in front of the podium. It should be turned on.
Okay.
Okay.
Can everybody hear me?
There we go.
Yeah, that one's on.
Oh, you want to use this one? April.
Okay.
Mhm.
Position number 1 is reset SAP A2. Position number 2 is a plea. Position number 3 is a plea. Position number 4 is reset further notice defendant was released. Position number 5, reset SAP 726. Position number 6 is a transfer to the DA's office. Position number 7 is reset SAP competency calendar 8-6. Position number 8 was a plea. Position number 9, I have it as a reset, no reset date. What will be the reset date?
Number 9, Fontenot. Does anyone have any information on that one?
Mr. Finley, is this your case?
Yes, give me one, let me look at my, oh yeah, I'm gonna reset her 2 weeks if I can.
That's 8-2.
8-2, yes, ma'am.
Yes, ma'am.
Okay, position number 9 is going to be reset SAP 8-2. Position 10 was a plea. Position 11, reset further notice defendant released. Position 12 was a plea. Position 13, reset further notice defendant was released. Position 14, reset further notice jail jury. The case was arraigned. Position 15 was a plea. 16 was a plea. Position 17, reset SAP 726. Position 18 was a plea. 19 was a plea. 20 was a plea. 21 was a plea. 22 was reset further notice with the bond amended to $4,000 pre-trial bond. Position number 23 was reset further notice jail jury arraigned. Position 24, reset to the competency 8-6. Position number 25, reset SAP 726. Position 26 was a plea. Position 27, we're holding for. Position 28 was a plea. Position 29, reset SAP 726. Position 30 was a plea. Position 31, reset SAP 726. Position 32, reset SAP 726. Position 33 was a plea. Position 34, reset further notice defendant was released. Position 35 was a plea. 36 was a plea. 37 was a plea. Position number 1 for the add-on was a plea. Position number 2, add-on, reset further notice defendant was released. Position number 3 and 4 were pleas. And position number 5 is going to be a transfer to the DA's office. So right now it's reset further notice. Any questions?
Your Honor. And then,
Can you please, my apologies, on position 23, can you state that one more time? I thought it was let's see, I thought it was reset, but you said you didn't give a date, I don't believe. I think it was 23.
Reset further notice jail jury. It was arraigned. There's no date at this time. Division
Thank you.
We're ready at the South Annex, Your Honor.
I'm sorry?
We're ready at the South Annex with Ms. Sams.
Right, okay.
What position is this, Your Honor?
This is position 27.
that might be PD Helen's case, who's on the phone with the bondsman, or
Yeah,
Mr. Hayes.
yeah, that is Ms. Helen's case.
Are you ready for him to come back in? Your Honor?
Is he still talking?
And Judge, we can move forward. I believe that's my last position, 27. That's a negotiated plea.
Great. All right, this is case number 19 CR 007875E. Benny Beatrice Sams, you're charged with possession and use of drug-related objects, giving a false name to law enforcement, both with the offense date of April the 4th, 2019. This is a time-served plea. Go ahead, state.
Yes, Your Honor, that is the only condition is time served, 13 days.
13 days. All right, Ms. Helen, is that your understanding?
It sure is. And we stipulate to the factual basis, venue, and ID, Your Honor.
All right, Ms. Sams, can you raise your right hand for me, please? Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury? All right, put your hand down for me. Are you under the influence of any medication, drugs, or alcohol at this time?
No.
Are you satisfied with the services and representation of your attorney? Do you understand that by pleading guilty, you're giving or waiving up the right to the presumption of innocence? By pleading guilty, you're giving up the right to remain silent and not testify against yourself? By pleading guilty, you are waiving the right to trial by judge or jury, whichever you prefer? And has anyone told you that you will receive a lesser sentence for pleading guilty today?
Repeat that again, please.
I'm sorry?
Can you repeat that again?
Put your mask down for me just for a second. I can't hear you.
Will you repeat that again?
Oh, repeat that again. I'm sorry. Has anyone promised you anything to plead guilty today?
No.
Okay. Has anyone told you that you'll get a lesser sentence for pleading guilty?
Yes.
I'm sorry?
Can you repeat the question, please, ma'am?
Okay. Has anyone promised you that you will receive a lesser sentence just by pleading guilty?
No.
Okay. And do you understand that if you're currently on probation, your probation may be revoked if you plead guilty, if you're on probation?
Yes.
Okay. Do you offer this guilty plea freely and voluntarily with the full understanding of the charge against you?
Yes.
And to the charge of possession and use of drug-related objects, how do you plead? How do you plead to that charge?
Say what now? I understand what you said.
To the charge of possession and use of drug-related objects, how do you plead to that charge?
Guilty. Guilty.
Okay, and to the charge of giving a false name to law enforcement officer, how do you plead?
Guilty. That's just my name, though.
Okay.
It's my middle name.
Hold on, that's just a yes or no question. I understand, but it wasn't your correct full name, but you're pleading guilty to that charge. Is that correct?
Yes.
Okay, and so you're getting a time served plea, no conditions, 13 days, credit for time served, and you will be released as soon as you're cleared, okay?
Yes, ma'am. Thank you very much.
All right,
Thank you, Judge.
back to you. You're welcome.
And we're ready on the bench warrant case, Judge.
Okay. And thank you all for your patience.
Your Honor, may we be excused from the South Annex?
Yes, ma'am. See you next time. Thank you, Deputy. Appreciate it.
Welcome.
All right. Please stand, sir, for me. This is the case State versus Daquan Reed Hayes, 21 CR 005137F. The charge is battery, family violence, and obstruction of a law enforcement officer, both with the offense date of September the 28th, 2021. You are Mr. Daquan Reed Hayes?
Yes.
Okay. All right. You can have a seat for me. State.
I would ask that pretrial reads the history, please.
Okay. Pretrial.
UCIC indicates 25 cycles with history in Georgia, Pennsylvania, Maryland, and New Jersey. Last arrest was January of 2019 for forgery and theft by deception in Pennsylvania. No disposition listed on that arrest. Nothing further to add.
Yes, Your Honor. This defendant FTA'd, I believe, back in, give me 1 second.
Okay.
Back in, just had it now. Odyssey wants to freeze. He FTA'd February 18th of 2022 in front of Judge Richardson. I understand that the defendant has updated his address with the clerk and is asking for the bench warrant to be set aside. However, that's not a valid reason for not missing court. I looked at his address change. It's the same address as the incident location. There is no return to sender that was filed with the clerk's office. So that means he did get his notice to appear. As pretrial has stated, he has 25 cycles in over 3 states, I believe. He's no stranger to the criminal justice system. He knows how it works. You have a court date, either you show or you don't show. He chose not to show, so he has a bench warrant. I asked that the bench warrant is not set aside. I do see that Judge Richardson did not set a bond amount on that bench warrant, but the state will be requesting that $1,000 surety bond is assigned to that bench warrant. Again, he has over 20 cycles in 3 states. We have spoken to the victim initially, and she communicated to the state that she was very fearful. So the state does have concerns with victim safety. It's not like he just missed his court date yesterday and remembered today. This was over 5 months ago. He was supposed to be in court. So for all of those reasons, we would ask that the court keep the bench warrant intact, and he's remanded into custody, and he posts a new bond in the amount of $1,000 surety.
Right. All right.
Judge,
Miss-
before you go ahead, the warrant has a $14,000 surety on it. I'll email it to everybody.
Thank you, Mr.
Okay, well, when I checked, it says 0. So I know his
Yeah, I think that
initial-
was, I don't know what happened on that, but the warrant has a $14,000 surety on it. So I'll email it to everybody.
I know the initial bond amount was 7,000. So I know the routine of some judges are, if you FTA, they'll double your bond amount. I'm not going to ask for a $14,000 surety bond, even though I do think this is a serious case, but I think $1,000 surety bond is reasonable for an amount to be set on the bench warrant, and it's the state's opinion he needs to be remanded to custody.
All right. And Mr. Hayes, are you represented today?
Yeah, Judge, it's me.
Oh, the Lord. You know what? I'm like, where's your attorney? She's on the screen. That just shows we're all hungry. It's after 12.
We are.
But it's okay. I'm sorry, Miss Helen, go forward.
Yes, Judge, this is a bench warrant hearing. When I spoke to him, I actually printed out that notification. His email, it looks like it's QuanYB132. It's actually, that's an L. So we've got an up-to-date correct email address. If you look on Odyssey, his address is 2100 DeForest Ferry Road. That apartment number is inaccurate. We have an up-to-date apartment number of 330. When I spoke to him, he understands it's his responsibility to update any changes to the court. He did not update that apartment number and did not receive the February 18, 2022 notice. I also want to let the judge know, since then, he's been following those bond orders, Judge, of no contact with Ms. King, has had no contact at all with Ms. King. The 2100 DeForest Ferry Road is leased in his name. Ms. King left in 2021, is no longer at that address. So he did not receive it due to the apartment number. We have that updated. This is an FTA from February, Judge. I would ask that the bench warrant be set aside so that he can come to these court dates. He takes this case seriously, as you see him in court right now with his bonding company. He takes this seriously, Judge, and he is trying to come to all court dates. We have it updated, and we're asking for the bench warrant to be set aside.
Give me a little more background on Mr. Reed Hayes, please. Age.
Yes, and email. Oh.
Do you know
Mr. Daquan, how old are you?
I'm 27.
27, okay. What about your work history?
I work at Papa John's right now and Kroger.
Work where?
Papa John's and Kroger.
Papa John's and Kroger. You have any children?
One.
How old?
1 year old.
1 year old. State, do you have anything else to add?
Nothing else, Your Honor. Like I said, he's a multi-state offender with over 20 cycles, and he's 27 years old. This court date was 5 years ago. You know the rules of the game. You have a court date, you show or you don't show. If you change your address or if there's an issue with your address, you have to file with the clerk's office. I'm pretty sure, I can't speak for the bonding company, but if you stay in contact with the bonding company, I'm sure they will tell you your court date.
They didn't hit the court date either.
Oh, hold on, Mr. Daquan.
Well, I'm not going to address that, but with that being said, it's ultimately the defendant's responsibility. He did not show the court, and we ask that the bench warrant is not set aside.
And
tell me your name, ma'am, please.
My name is Shannon Cagle. I represent Reggie Cagle Bonding Company.
All right, and what would you like to say?
I would just like to say that we were not aware of the missed court date until the bond forfeiture judgment calendar came up, and then I reached out to him. I had absolutely no problem getting in touch with him and getting him down here. Therefore, we'd like to just remain on his bond.
Okay.
That's all, Your Honor.
Okay.
And Judge, I want to say that his bond company is here to represent him. He's here. He's a peer, Judge. This is not someone who's trying to run. I hear his history. Please set aside the bench warrant. He is working. We don't want an interruption in his occupation, his income, and also him being at home with his child.
All right, I'm going to set aside the bench warrant. And so are we reinstating the bond or am I getting a new bond?
Well, the state was asking for a new bond. I think that's up to you.
Okay.
The state was asking for a new bond in the amount of $1,000 surety. I know Judge Richardson said a $14,000 surety. I don't necessarily think that's reasonable, but the state was asking for a new bond.
Okay. Right, then it'll remain the same. All right, and it is what is it with you now, Cagle?
I'm sorry, I just need to grab
The bond? Oh, yeah, go ahead.
I'm sorry, I was muted, Judge. What was your last statement?
Bonding company is getting me the amount of the bond.
It was
He was released on a 7,000 good bond, Judge.
7,000 good bond. All right,
Yes.
we will reinstate the 7,000 good bond. And lesson learned, Mr. Reed, and let's just make sure to keep everything up to date. All right.
And Judge, I will submit that set aside order to Ms. Champion right after court.
All right, thank you so much. All right, does that conclude everything, everyone?
It does, Judge.
Was there a second DV case or no?
I
No,
had
sir.
just one.
If we have another one, you're buying lunch.
It was just one, Judge.
Okay, well, with that being said, Your Honor, if I can introduce the new intern that we have, I just wanted him to have the
Yes,
opportunity
okay.
to meet you. His name is Mr. Roberts. I'm not
Where's your
sure.
new intern?
Okay, there goes Mr. Roberts. He's a student at UGA, I believe, but I will let him address the court.
Yes, hello, welcome, Mr. Roberts. It's a long, interesting day. Where are you in school?
Hi, my name is Terrell Roberts. I currently